Yes, my lord. When the proposal was sent for provincialization of the services of the teaching and non-teaching staff, the petitioner was left out. Rightly, it was left out because at that point of time, he did not have, my lord, PhD. At that point of time, he was the in charge principal of the college.
Yes.
Now, my lord, pursuant to that provincialization process, other than the petitioner, my lord, all the eligible teaching and non-teaching staff were provincialized.
Their services were provided.
Yes. And my lord, in the meantime, my lord, the petitioner acquired the, my lord, PhD degree that your lordships will get at page 32.
Dated?
It's dated, my lord, 13/3/15.
13/3/15.
15, my lord. Yes.
When was the exercise for provincialization?
Earlier process was initiated in 14, my lord, 21/14.
Okay.
Yes. So, my lord, based on that, the director of higher education, my lord, on 5/11/15 forwarded, my lord, the case of many persons
Left out teachers.
left out staff,
Including-
including the petitioner, my lord. Now that was on, my lord, 5/11/15 at page 36. Then, my lord, based on that, on 11/6/18, the DHC sought for hard copies of the PhD certificate. This continued, my lord. In the meantime, what happened, my lord? The one Mr. Nosad Ali Ahmed was also aspiring for in charge principal of the college, my lord. He instituted a writ petition that is 5258 of 21.
What was his cause of action?
My lord,
What was his cause of action?
cause of action was, my lord, his case was that he is eligible to hold the post of in charge principal.
But your client was holding.
All, yes. Then, my lord, based on that, an order was passed by this honorable court on 6/10/21, whereby, my lord, the competent authority was directed to consider his case, that Nosad Ali Ahmed, petitioner in the other case. Now, in purported compliance of the order dated 6/10/21 in WPC 5285, my lord,
5258.
5258, the authority passed an order whereby the charge of DDO was given to the in charge. Sorry, inspector of schools. So colleges, no? Inspector of colleges. And, my lord, other functions were confined to the petitioner.
Petitioner means no sir. No sir.
No,
You
present petition. Yes,
petition.
yes. That was in purported compliance of the order passed by this honorable court. In the meantime, my lord,
You say other than the functions of DDO, the other functions were retained with you.
yes, financial power was given to the, my lord,
Yes.
IS. Now, as a result, my lord, neither my learned friend's clan nor we are getting anything. That's the whole difficulty.
Who is for no sir? You
My lord. Now, my lord, will kindly come to page number 50.
page number 50.
50.
Yes.
In pursuance to the government OM dated 23/5/17, and as per the provisions of the Assam Education Provincialization,
Of which case?
page 48, my lord.
Of 3723.
No, my lord, 25/10/21 order.
No, which WPC? 3723.
Oh, sorry, my lord. Yes, 3723.
50, page 50.
No, my lord, 48. I'm sorry.
Annex 10.
Yes.
Yes, please.
In pursuance to the government OM dated 23/5/17, and as per the provisions of the Assam Education Provincialization of Teachers and Reorganization of Functions of Educational Institution Act 2017, as amended in 2018, the tutor principals are allowed to act as in charge principal to look after day-to-day activity of the and the member secretary of the governing body of the provincialized colleges. The colleges having no principal or tutor principal, the senior most assistant professor is allowed to act as in charge principal and member secretary of the governing body. What has happened, my lord? Prior to that, at page number 62, my lord,
Yes.
the petitioner was appointed as, my lord, tutor principal under the scheme of the act. That order, my lord, will get at page number
52, yes, sir.
62 is the operative portion, my lord. Before that, yes, 62. Government of Assam in the Higher Education Department has sanctioned 690 numbers of principal, tutor, principal, so and so, for provincialization of 134 provincialized college, so and so, number of post of principal, tutor, principal, so and so, assistant professor, tutor, assistant professor for provincial services of 7 new degree colleges of Assam by government sanction order dated so and so. So, my lord, the petitioner was appointed as at page 62C, serial number 418, my lord. Page 62C, last 418 serial number.
Your name is Abdul Kalam.
Yes, my lord, he is the petitioner. Dr. Abdul Kalam Azad, tutor principal, Kuntali Anshalik College. So, my lord, in view of this order, as tutor principal, the petitioner was appointed as in charge and member secretary of the GB. Am I clear, my lord? Now, my lord, this order was put to challenge by Nausad, that is my learned friend's client.
Which order?
This order of 25-10-21, allowing tutor,
Giving you the in charge.
yes, in charge. That was challenged by my lord Nausad Ali, and that order lordships will get at page 50, whereby this honorable court, my lord, state the order.
Page
50, my lord. And the operative portion is at page 53. Para 13, my lord, last but one para. In such view of the matter, appointment of respondent number 6, Abdul Kalam Azad, as the in charge tutor principal of the college is stayed until further order. The director may now comply with the earlier order dated 6-10-21 in so and so, bringing the process for appointing the principal to its logical end by passing a reasoned order, meaning thereby that the person to be appointed as in charge principal should be duly qualified under the law to be so appointed, and not to bring person who is disqualified for the purpose, and for doing it, any person who would be suitable may be considered. So effectively, my lord, my appointment as in charge principal
But
was in
25-10 was the general order.
general order.
No, where was in pursuance to this order, you are given the charge.
Yes.
But this order has as such has been stayed.
State. General order, my lord. And my lord, be that as it may, I am not raising that issue now.
But since this order was also giving benefit to you, your thing has also been stayed.
Yes.
Thereafter,
Yes. Thereafter, my lord,
who was running the college?
my lord, inside IS was discharging the function of the
DDO.
DDO.
Uh.
And my lord,
Right.
this function has now been given to principal of another college.
In pursuance to this order.
Yes. Page 61.
Hmm. 51.
Yes. 24/5/22. In compliance of the Honorable Guwahati High Court's order dated 24/1/22, in WPC number 353 of 22, the provincialization of service order in respect of Abul Kalam, tutor principal, Kontoli Ansalik College, issued by order that it is kept in abeyance under further orders. The charge of principal and secretary of the governing body of the Kontoli Ansalik College is temporarily entrusted to principal Jain College Boko in addition to his own duties. So the principal of Jain College is also the principal in charge of the present college. So this is how the matter stands. My lord, the problem is, my lord, my appointment as tutor principal is nowhere under challenge. As a result of this order for the last, my lord, May 22, I am not getting my salary. My lord, fact, lordship will appreciate one thing. If not as principal, otherwise I am eligible for provincialization, my lord. I have been deprived of all benefits, my lord. Otherwise, nobody can stop me from, getting my services provincialized as an assistant professor or lecturer. Because I was holding the charge of principal, that is why for
You
the...
said that on 5/11/2015,
Yes,
the residual list also included your name.
exactly.
And thereafter, an exercise was carried out to verify your PhD,
Yes,
which was done.
done.
Now there should not be any impediment.
Exactly, my lord. Therefore, the authorities should consider neither my learned friend's client is gaining anything nor I am gaining it. So they should holistically take a view in respect of the whole matter. Now, government would like to say that my PhD degree is at cloud. My lord, that mere expressing doubt will not do. You must take a call. So therefore, my humble submission is, my lord, the whole case, all the matters should be remanded back to the director.
Yes.
He should apply his mind and pass a speaking order. That's my case, my lord. Huh? And meanwhile, my lord, my salary should be released, my lord. At least as a tutor. From May 22, I have not received anything, my lord. That is my case, my lord.
Yes. Talk about you for no sir.
My lord, the lordship find permission. Deeply.
This is only the in charge arrangement.
Yes. No, this is not for in charge, my lord. In fact, now authority will, because the principal of Jain College is already, discharging his function. Let that continue. But then, my lord, in the meantime, by giving a time frame, my case should be considered.
No. Otherwise, this is going on an in charge basis.
Yes.
They should-
In fact, I have a claim for substantive appointment,
they
and
should-
my case has been
This
recommended.
is consider for regular appointment of them.
Exactly.
Within a time bound frame.
Yes, my that is my prayer. Because pendency of this proceeding, neither my learned friend, none, no.
Neither the system is also being helped.
Yes. How can
Now,
my lord a
principal of-
principal hold dual charge? That is my prayer, my lord.
Yes.
Deeply.
May praise the Lord.
Each Chakraborty.
Lordship. Lordship, our case was to the extent that Lordship,
You are in WPC.
Lordship, I mean, item numbers 2, 3, and 4, Lordship, WPC 6427 of 20.
6427.
Lordship.
Thank you. Yes.
Lordship, as my learned friend had already pointed out, Lordship, in restriction number 6427, we had challenged the speaking order, which was passed in pursuance to the earlier orders of this honorable court, whereby my appointment was not considered for in charge principal and the private respondent herein was
What
appointed.
was the order challenge? What did you challenge?
Lordship, the speaking order, Lord.
Dated?
Lordship, order dated 26/10/2021.
26, 10,
2021.
20,
21, Lordship.
21.
Lordship.
So what was that order?
Lordship, by this speaking order, Lordship, my case for appointment as in charge principal was rejected, and the private respondent was appointed as in charge principal, and the inspector of schools was entrusted with the power of drawing and disbursing.
Okay.
Now, Lordship, after filing of this writ petition, Lordship, we came across the order passed by the government, wherein they had allowed tutor principals to act as in-charge principal. That is under challenge in Lordship writ petition 353 of 22, Lordship.
You filed?
353 of 22, Lordship.
Challenges the OM.
Lordship, writ petition 353 of 22.
It challenges the OM.
It challenges the order, Lordship, 25/10/2021.
That
Page
was an OM. That was an OM.
that is an order, Lordship, in pursuance to a government OM.
Yes.
Page 35 of Lordship, writ petition 353 of 22.
Okay. You challenge this order.
Lordship, we challenge this order, Lordship.
15.
Lordship.
Yes.
Lordship, we had challenged this on the ground that the Act of 2017 provides an express bar that tutors cannot be appointed as principals. Your Lordship takes up section 2U of the Act of the Reorganization Act of 2017, Lordship,
Which page?
page 105,
Same, this
Lordship.
105.
Lordship.
Yes.
Lordship, the proviso to section 2U, Lordship. May I read it, Lordship?
Yes.
Lordship, provided that the tutor shall not be eligible to hold the post of professors, vice principal, headmaster, assistant headmaster, superintendent, assistant superintendent, as the case may be in an educational institution provincialized under this Act. So under this proviso, basing on this proviso, Lordship, we had challenged his appointment as in-charge principal. Because the Act provides an express bar that a tutor cannot be appointed, and he was not he was a tutor, Lordship. He was not provincialized as an assistant professor. Under this context, Lordship, we had challenged subsequently, our Lordship, in view of this, and a stay order was passed, restraining him from functioning as the in-charge principal. And that is how this matter has come up, Lordship. And Lordship, in the meantime, they have filed an affidavit, Lordship.
Who has filed?
The department has filed an affidavit in 353 of 22.
Yes.
Now, Lordship, the thing is, Lordship, it is admittedly a fact that this private respondent is the senior most employee in the college,
Who,
Abul Kalam Azad, which my learned senior
Hmm.
presented. Now, Lordship, if his case is considered and if the department is of the view that his PhD is valid and he is granted, then I do not have a case because he is admittedly the senior most. Now, if that is not done, Lordship, by virtue of him being a tutor, he cannot be appointed as a principal,
But if his PhD is held to be valid,
Lordship.
then the barrier of tutor
Yes.
is removed.
Lordship. Yes. Then that is removed, Lordship. But as on date, Lordship, that has not been done. Now, Lordship, in view of that,
But they should take a final call.
Lordship, that is that. Yes.
My lord, actually, yes, my lord, the matter has to be remanded and decided by the director only, my lord.
Hmm.
Because actually, the petitioner in the first item number 1, my lord, Abul Kalam Azad, he was initially provincialized as tutor principal, my lord. Because he was not, at venture stage, my lord, he was working as a principal in this college, my lord. That's why when the provincialization was carried out, my lord, he was provincialized as a tutor principal. And this, my lord, the notification, my lord, by which tutors were allowed to hold as a tutor principal, my lord, that was done for smooth functioning of the colleges, my lord. The notification, my lord,
35,
yes, my lord.
2510.
2510, my lord.
2510.
Yes, my lord. For better administration and smooth functioning of the college, my lord, as a temporary measure. And because of this,
But
Stay-
Mr. Chakraborty has showed the provision of the
yes,
rule.
my lord.
There is a bar.
There is a bar, my lord, to act as a principal, my lord. That's why, my lord, what my instruction is that he has been, that's why, my lord, he has been provincialized as a tutor principal, my lord, not as a principal.
What is the difference between a principal and a tutor principal? Except the nomenclature. Is there any substantial difference? Perhaps there is none, except the name. Okay.
Maybe he's not getting the salary, my lord, as
Salary,
principal.
why haven't you at least released the salary so far as his services as tutor is concerned?
But the whole difficulty was what is arisen, my lord, because of his stay order, my lord. Uh, the Abdul Kalam Azhar was,
No, stay was with regard to his arrangement as principal or in-charge principal.
yes,
His
my lord.
substantial appointment is not the subject matter of any writ petition as a tutor.
Yes, my lord, that was not, but the
So-
thing, but what is difficulty, what?
What is the difficulty
department-
on your part to take a
Department is getting
decision?
difficult, my lord,
You're running the administration.
because
Okay, principal is not there. He's a tutor. Give him the salary of tutor. Almost a year has more than a year has passed. You have not paid the salary of a person. How is he going to survive? For that, you don't need a court order. Court has said stay. Okay, stay. Then come back to the substantial post of tutor. Pay him tutor.
but I spoke to the authority, my lord, what they said that what they are getting the difficulty, my lord, because as he was provincialized as a tutor principal, had he been provincialized as a my lord, tutor assistant professor or something like that, my lord, then he could have reinstated as a tutor assistant professor, my lord. But as he was provincialized as a tutor principal, and that's why, my lord,
That is the decision you need to take. You cannot leave a person high and dry like this. Court has passed an order, that is okay, but at least in a substantial capacity, you should pay the salary. Okay, we'll consider. Yes, anybody else? Mr. Bustakorma? For? Here for whom? As Bustakorma. For 30. In WPC 3723.
I'm in for item number 4.
Your name?
S. Parikh.
R3 is the principal of the college, other college. Principal of and madam, what is your name?
S. Parikh on behalf
S.
of
Parikh.
S. The item number 4.
WPC 22. Item 4.
Yes.
You are for?
Respondent P on behalf of SK.
That is understood. Who is respondent number 3?
Respondent is for the accountant general,
So he don't have any.
you know. And my lord, the degree of Abul Kalam Azad is also doubtful, madam, the PhD degree he has
You
done.
take a call.
Yes, madam, the department,
You
let
take
the
a
matter
final
be.
call. If you say the degree is not acceptable, pass a final order.
Yes.
Let him be in a position to challenge your order.
Yes.
You're for the higher education.
Yes, madam.
A tutor, if he has the PhD degree, he is entitled for holding the post of principal
Principal, madam.
substantiated.
Yes.
Third, all these petitions being connected were analogously heard, have been analogously heard and are being disposed of by this common judgment and order. Full stop. While WPC 3723/2022 is instituted by one Abul Kalam Azad, the rest of the cases, namely WPC and contempt case, no? Are instituted, have been instituted by Nausad Ali Ahmed. Full stop. The dispute is with regard to the post of principal of Suntali Anchalik College, Boko, in the district of Kamrup. Full stop. Para. I have heard Sri K.N. Chaudhary, Senior Counsel, assisted by
A. Ali. A. Ali.
A. Ali, learned counsel for the petitioner in WPC 3723 of 2022, whereas the petitioner in the rest of the case is represented by Sri H. Chakraborty, learned counsel. The department is represented by Sri S. Das, learned standing counsel, whereas
Higher education.
higher education department we have.
Yes.
Whereas MS S. Padik, learned counsel appearing on instruction of the SK Meet, standing counsel, is present for the AGS. Sri S. Vishwakarma is present for the response number 3 in WPC 3723 of 2022. The government is there, party no. Sri T.R. Gogoi, learned state council, is also present. The College. The college was the venture one in which Sri Abul Kalam Azad was acting as the principal. On 21/2014, an order was passed for provincialization of the services of the college of venture colleges. However, the name of Abdul Kalam Azad was left out as he did not have the PhD. It is the case of the petitioner Abul Kalam Azad that subsequently on 13/3/2015 he had obtained the PhD. Whereafter on 5/11/2015, the Director of Higher Education had issued a list of candidates who were left out, and that list included his name. Pursuant to the same process, it is claimed that on 11/6/2018, The hard copies of the degree, copy of the degree was called for. Full stop. The petitioner was allowed to hold the post of tutor principal. Tutor principal? Tutor principal. Full stop. The aforesaid arrangement was, however, the subject matter of challenge by the petitioner in the other cases, Sri Naushat Ali, who had filed WP 5258 of 2021. Correct?
Lordship, and 6427.
Huh?
Lordship, yes, 5258. 5258.
5258.
Lordship.
Full stop. Full stop. Where he paid to allow him to be appointed, allow him to discharge his function as incharge principal of the college. Full stop. This court, by order it is 6/10/2021, had directed for consideration of the case whereafter, the charge of the royal and disbursing officer, between DTO, was given to the inspector of schools, KDC, where however, the other functions, Sri Azad was allowed to retain the other functions. Full stop. In the meantime, an order was passed on 25/10/2021, whereby tutor principal was allowed to hold the post of incharge principal, and the said order was said to be pursuant to an OM dated 23/5/2017. Full stop. Prior to that, by an order dated 18/8/2020, the department has granted sanction for tutor principal, and in the list appended thereto, the name of Sri Azad found placed against serial number 418. At this stage, Sri Naushat Ali instituted WPC 353 of 2022, and this court, by order dated 24/1/2022, had stayed the impugned order dated 25/10/2021. Full stop. Pursuant to the state direction passed in WPC 353 of 2022, an order has been passed by the department on 24/5/2022, whereby the incurred arrangement has been entrusted to the principal of another college, namely JN College, Boko. Full stop. Sri Chaudhary Jalan Senior Counsel, appearing for the petitioner in WPC has submitted that since May 2022, his client is not even been paid his salary, even in the substantial capacity as a tutor, and therefore he is facing immense hardship and inconvenience. Full stop. He further submits that the present arrangement by which the principal of another college has been given the charge of the college in question was not the purport and objective of the orders passed by this court, and is also otherwise against the interest of public service. Full stop. The senior counsel accordingly submits that appropriate directions are required to be passed for resolution of the dispute by the department. Full stop. Since an issue regarding the genuineness of the PhD of the petitioner was also raised, the senior counsel submits that till date, no decision has been rendered, and therefore merely by raising a doubt cannot deprive his client for due consideration and to allow him to hold the post of principal of the college, as there is no dispute that his client is the senior most in the college and was also discharging the services as principal during the venture stage. Full stop. On the other hand, the A. Chakraborty, learned counsel appearing for the petitioner Naushad Ali in the other cases, has submitted that in the present in writ petitioner in WPC 46427 of 2021, the subject matter of challenge is the order dated 26/10/2021. Full stop. He submits that right the impugned order dated 26/10/2021, the claim of petitioner Naushad Ali for in charge was rejected. However, rejected, and the arrangement was continued with the
Abul Kalam.
Abul Kalam Azad, and only the financial powers of BDO was given to the IS. Full stop. He further submits that under the So-and-so Act of 2017, there is a bar for allowing tutors to hold the post of principal, and in this connection, he refers to section 2 within bracket U bracket close provide refers to the proviso to section 2 within bracket U. Full stop. He submits that the order dated 25/10/2021 was in violation of the aforesaid provision of law, and therefore the second writ petition WP 353 of 2022 was filed. Sri Chakraborty, however, fairly submits that Sri Abul Kalam Azad is senior to his client. However, since the PhD of Abul Kalam Azad is under a cloud, his client should be allowed to hold the post of the interest principal till a regular process is conducted to appoint to fill up the post. Full stop. Para. 3. Thus, the learned standing council of the department has submitted that the petitioner in the first case, Abul Kalam Azad, was the principal of the college at the venture stage, and therefore, at the time of Miscellaneous, he was made the tutor principal. Full stop. Full stop. With regard to the justification for issuing the notification dated 25/10/2021, which apparently is in violation of the proviso to section 2 Q of the Act of 2017, the Learned Standing Council submits that the state was a temporary measure for smooth functioning, and in any case, the arrangement was only on imperative. Full stop. The Standing Council, however, reiterated that the PhD of the Abdul Kalam Azad is doubtful. Full stop. Sarah. 3. As Vishwakarma Learned Council has appeared for the response number 3 in WPC 3723/2022, who is the principal of the nearby JN College, who has been given the additional charge, and therefore he does not have much to submit in this controversy. MS Parikh, the Learned Council, who has appeared for the AG, also does not have much role to play. The controversy is with regard to the post of the principal of the college in question, wherein initially Sri Azad was made the in-charge principal, tutor principal, in-charge tutor principal, which after the orders of this court has been modified by allowing the principal of JN College to hold additional charge of the college in question. Full stop. By the earlier order dated what was the date for DDO power? By the earlier order, the financial power of the school was already given. Financial powers of DDO of the college was already given to the inspector of school.
Actually, there is an order that is 18/5/2020.
Earlier order 18/5/2020 was already given to the inspector of school, Kamrup district circle. Full stop. Thereafter, this court finds force in the contention of Sri Chaudhary, which is also not disputed by the Learned Council for the other parties, that the present arrangement is benefiting none and cannot be a final solution to the dispute which has arisen. This court, after consideration of the matters in its entirety is of the opinion that the resolution is required to be resolved, the dispute is required to be resolved at the stage resolved by the department itself. Director, correct?
Yes, madam.
The department itself by the director of higher education. Full stop. The contention raised by Sri Chakraborty by taking recourse to the proviso of section 2U of the Act is also a relevant factor which has to be taken into consideration. Full stop. However, this court is also of the opinion that unless the department or the appropriate authority takes the final call on the PhD of the petitioner Abul Kalam Azad, mere suspicion would not be enough to disentitle him for a consideration for appointment as principal of the college in question. Full stop. This court is also of the opinion that in-charge arrangement cannot continue indefinitely, as all such in-charge arrangements are to be replaced by are to be discontinued and a regular appointment be made. Full stop. In view of the above, this court remand the entire dispute to the Director of Higher Education, Assam, who shall for consideration of the matter, the parties to the dispute, namely Sri so-and-so and parties to the dispute and parties to the dispute who are petitioners in the respective cases are directed to appear before the Director of Higher Education on, tell us the date. Today is 14th. On 25th,
What's your pending?
25th?
Yeah.
25th, with all documents. Whereafter, the Director, to his convenience, may either consider their cases on that day or any other date. Director may consider or any other date as convenient. Full stop. The dispute is, however, directed to be resolved within an outer limit of 45 days from the date of first appearance, that is 25th. Full stop. The issue with regard to payment of salaries to the petitioner Abul Kalam Azad is also to be decided, as his claim that he is not getting salaries since May 2022. Full stop. The present arrangement by which it is further made clear that on resolution of the dispute by a speaking order, the present arrangement by which the principal of Allen
Jane.
and all Jane College has been directed to, has been given additional charge of the college would discontinue, and the principal to be appointed on regular basis would also be given the full power, full financial powers, including that of CDO.
My lord, another aspect, my lord, director is to decide also, my lord, if, my lord, this degree of the petitioner Abul Kalam Azhar
That
is
we have
not,
already said.
not, my lord,
That
then
we have already said. You have to take
what
your
will his position, my lord?
no, see, only because doubting you cannot pass an order. You have to
No,
say
no,
that
no,
this
I'm
is
saying that if the degree is found to be genuine, my lord, then obviously he will.
that is something within your domain. You can always say the degree is not genuine.
If it is not found genuine, my lord, then, my lord,
See, that part is not a dispute before us.
no, I am saying that, my lord.
Have you raised there is it's not the issue before us. We have already made sufficient observation in this judgment with regard to his degree. How do you treat the degree? If you say the degree is not genuine, you pass an order.
Yes, my lord. That's what, my lord, I'm saying that then his position, because that department is saying, my lord, that he has been provincial as a tutor principal, then we could not.
That is something which you have to decide. Don't trust this to the court. That is not a part of the dispute.
Yes.
Petition says dispose of. So contempt also we are disposing of. Interim orders passed earlier, change vacated, so as to enable the director higher education to take a final call. No, don't vacate. Don't vacate. Because, I'm way to order something. I would put it another.
Right.
Right. May I please, your lordship? My lord, civil division, my lord, again the imping judgment dated, my lord, 17/6/2023, passed by the civil judge, my lord,
Just
in Miss appeal number, my lord. My lord.
Yes, please.
Lord, the revision, my lord, against the imping order dated 17/6/2023, passed by the, my lord.
Who are you?
My lord, I am the, my lord, defendant, petitioner defendant. my lord.
Petitioner is the
In
defendant.
the suit, we are the defendant.
Okay, suit for
Suit for, my lord, declaration of, my lord, the right title, not right title, my lord, suit for injunction, permanent injunction and consequential relief, my lord. They institute the suit, my lord.
yes.
And thereafter, my lord, the injunction was granted. And against the injunction order, we made an appeal. Appeal was dismissed, my lord. Thereafter, we challenged this appellate judgment, my lord. That is at page 77.
Appeal filed by you. Dismissed.
Dismissed.
Dismissed when?
Dismissed. It was dismissed on, my lord, 17/6/2023, page 77.
Means appeal number 7 of 22.
7 of 2022. At this stage, my lord, notice may go, let them come, my lord.
17 June. What is the permanent injunction?
No, that is, my lord, restraining the defendant from the suit land.
Entering into the suit.
Yes, my lord. Entering, no, rest. Yes, my lord. The suit length is in our possession, my lord.
Your position.
As of now,
So what was the permanent
since
injunction?
2012
For
as of
restoration
now.
of position.
Yes, recovery of possession also there.
No, no. What is the nature of the injunction?
Injunction, my lord, kindly come to page, my lord, 44.
4.
Yes.
Yes.
44, that is, my lord, order dated 29/4/2022.
By the municipal court.
Yes, my lord, Munship 1, my lord. That was
Petition
temporary
452.
injunction was granted. Accordingly, that was my lord,
Let us see the nature of injunction.
my lord.
Let us see the nature of injunction. Where is the order?
Yes, my lord. That is my lord, page 44.
Page 44, yes. Where is the operative part?
Operative part, my lord. Lord, page my lord, 51.
51.
This is my lord. The petition to take steps as per the proviso so and so and to the needful within the statutory period. The order is passed at 12:40, fixing.
You are restrained from entering into the land.
My lord.
You are restrained from entering into the land.
Yes, my lord.
You said
No,
that
no,
the
my lord. A land is in our possession.
land,
And they, my lord, on 4, my lord, cause of action was arose on 4/3/2022. They entered into the land, my lord. On that day, my lord, some altercation took place, my lord. Thereafter, they, my lord, institute the suit before.
no,
proceeding.
see, come to page 51.
Yes, my lord.
Please read this extract, order 39, rule 1B, R1B.
As
as
such,
such,
this court proceeds, grant a temporary injunction restraining the respondent defendant from entering the suit land. Till the
41.
filing.
You are restrained from entering the land.
But that is there, but my lord, as per my instruction, land is, my lord, in our possession. Since 2012 to, my lord, as of now.
Where is the suit? Where is the plaint?
Plaint is, my lord, at page 15,
1.5.
15.
Suit is not for recovery of position,
Permanent injunction and consequential relief.
not for recovery of position.
That is why, my lord, notice may go, my lord, at this stage. Let them come, my lord. Everything will clear, my lord.
Heard to be S.A. Ahmed,
Aye.
learned counsel for the petitioner, who by means of this petition filed under Article 227 of the Constitution of India has put to challenge an order dated 17/6/2023 passed by the learned civil judge Masip in Miss Appeal number 7 of 2022, whereby the order dated 29/4/2022 and 19/12/2022 passed in Miss J case number 53 of 2022, arising out of title suit number 37 of 2022 by the Munsif number 1, Sibsagar, has been affirmed and the appeal has been dismissed. Court of issue notice returnable by 6 weeks. That steps be taken for service of notice upon the sole respondent by registered post daily. Steps by tomorrow. Steps within 2 days.
Right.
Para rest after 6 weeks along with service report.
Oblige, my lord.
May it please the Lord. The respondents herein as plaintiff, they filed a title suit for right title, interest, and class possession. was decreed in their favor.
Hmm.
Thereafter, they filed an injunction petition restraining us from entering into the land, as well as,
No, you said the suit was already decreed.
yes, suit was decreed.
Thereafter, what is action taken?
Injunction, yeah, not to construct, not to further
In the
make
suit
any,
itself,
yes, not to make any further construction.
there was a decree
There was a decree.
for permanent injunction.
Yes.
Thereafter,
Thereafter, we violated that decree.
Hmm.
Then they filed a violation petition.
Hmm.
Now the Munshif Court held that held us liable and said that we are liable to 7 days of civil imprisonment.
Yes.
Thereafter, that was affirmed by the learned civil judge. Now, by this CRP, I am on only a limited prayer that may be modified and fine may be imposed of any like amount.
let us see the provisions. What are your consequences of violation?
Order 39, Rule 2A.
Consequence of disobedience.
Yes, Your Lordship. In the case of disobedience of any injunction granted or other order made under Order Rule 1 or 2, or breach of any of the terms on which the injunction was granted or the order made, the court granting the injunction or making the order or any court to which the suit or proceeding is transferred may order the property of the person guilty of such disobedience or breach to be attached, and may also order such person to be detained in the civil prison for term not exceeding 3 months, unless in the meantime the court directs his release. So under this 2A1, I have been penalized.
Where is the provision for penalty?
Penalized under this
No, where is
2A1.
the provision you said some, you'd pay some amount?
No, that is not there, but I'm asking for
No, if
modification.
there is no provision in the act, if the statute does not provide, how can we? And this is not or, you have seen the expression, it's and.
Yes,
How many days imprisonment?
7 days. Considering the fact that she is a lady.
Why did you violate? What was the injunction?
Injunction was to maintain status quo. That is at page 41
Status quo with regard to the supplement.
with regard to the suit land. Thereafter, admittedly, there was certain constructions made.
Let us see the order.
41 is the status quo order.
Page 41.
Page 41. Dated 13/4/2011.
Status. Where is the order impugned?
Impugn order is at page 48 is the order of the learned Munshif.
Dated
27/7/2018.
18.
Yes, 18.
Yes.
Second paragraph will be the relevant portion. In view of the decision arrived at as above, it is held that the opposite party is liable to suffer penalty by detention in civil prison. Considering the fact that the opposite party is a woman, I am of the considered opinion that 7 days of detention of her in civil prison shall be sufficient penalty for her. Hence, the opposite party is hereby sentenced to detention in civil prison for 7 days, and thereafter it was affirmed by the civil judge. Operative portion is at page 69. Page 69, para 20. Discussions and reasons. This court is of the considered opinion.
Now let us see the discussion.
Discussion will start from para 17, page 65.
The order is at where? Where is
Order starts from page
56
page 56, yes.
dated? 16
The
March.
16 March 2023. The discussion, page 65, para 70.
Yeah.
Mary, para 17 onwards, it is the plea of the present appellant that the notice was not issued in her address, but it was issued in the address of her husband, and that she lived at Red Cross Road, while the address mentioned in the summons was Mankota Road, which is situated at a distance of 2 kilometers from her address. However, on perusal of the evidence recorded in Ms. J case number 42 of 2011, it appears that in her cross-examination as witness number 1, the appellant Sandhya De has specifically stated that the notice to maintain status quo was received by her husband on 18/4/2011, and on 18/4/11 they were living together. Thus, in view of the above statement, in her cross-examination, it appears that the notice of status quo was served upon the appellant on 18/4/11, as rightly held by the court below. Moreover, the appellant has stated in her cross-examination that she knew about the case and that on 27/4/11 the appellant appeared before the court personally and took time to file her written statement. Thus, it appears that the appellant had knowledge of the status quo order. The record of Ms. J case number 42 of 11 reveals further that the court by order dated 25/11 directed the OC concerned VS to execute the order of status quo passed by the learned court below dated 13/4/11, and accordingly the same was executed by PW4, namely ASI Numal Barua, and as per his evidence, he had visited the suit land on 26/5/11, and he found that Sandhya De was engaging labor and construction was carried on, and ASI PW4 has directed the parties to stop work and to maintain status quo, and further they had taken signature of appellant Sandhya De. Although PW4 was duly cross-examined by other side, but no contradictory statement is found in such cross-examination to disbelieve the evidence of PW4, and appellant has not denied her signature exhibited by PW4. Moreover, the defendant appellant, who has specifically stated in her evidence that on 10/5/11 laborer were working for removing the shuttering, and she has simply stated that she has forgotten if the police had visited the working site and asked them to stop the construction. Witness number 2 of the opposite party, namely Kusumuddin Ali, has also specifically stated in his cross that on 26/5/11 police visited the construction site and asked him to stop the construction, meaning thereby that the construction was carried on till visit of police. Moreover, he has admitted that from 10/5/11 to 26/5/11 construction was going, and when police visited the site and asked them to stop the construction, they stopped, and Sandhya they did not ask them to stop construction, and she did not disclose the order of status quo passed by the order. Thus, from the evidence adduced by the parties, it clearly appears that the status quo order dated
That's
13/4/11.
also a very weak case.
Yeah.
See your prayer, there is no legal backing, there is no statute, provision in the statute.
This provision is not there.
If there is no provision, unless we find that this order is grossly illegal or patently erroneous or some perverse, in revision jurisdiction difficult for us.
By invoking 151 power, your lordship.
No, 151, but there has to be a provision in the statute under 2A that this is also one part. There is only one consequence. Third, Sri Siddhant Datta, Learned Counsel for the petition, who by means of this petition filed under Article 227 of the Constitution of India has put to challenge an order dated 16/3/2023 passed by the learned civil judge, Dibrugarh, in Miss Appeal number 2 of 2019, whereby the appeal has been dismissed and the order dated 27/7/2018 passed by the learned Munsif number 1, Dibrugarh in Meet J case 42 of 2011 arising out of TS number 58 of 2011 has been affirmed. Full stop. By the aforesaid order, the learned Munsif has passed an order of conviction of the petitioner for violation of the injunction order passed in Meet J case number 36 of 2011. Full stop. The counsel for the petitioner by drawing the attention of this court to the order impugned has submitted that a direction has been given for detention of the petitioner in civil imprisonment. Full stop. The learned counsel has submitted that the petitioner that the said direction may be substituted by any other direction by imposing penalty of payment of any cost or compensation, and the petitioner being a lady, her case may be considered. Full stop. Sarah. The first appellate court by the order dated 16/3/2023 has considered the case of the appellant and thereafter has rejected the has dismissed the appeal. Full stop. Sarah. The submissions made by the learned counsel is required to be examined in the context of the statutory provision given in Order 39, Rule 2A of the CPC. Full stop. For any reference, the aforesaid provision is extracted herein below. 2A1. 2A1. A reading of the aforesaid provision brings to a conclusion that the consequence of disobedience of any order of injunction is by attachment of property and detention in the civil prison. Full stop. The expression used is and therefore the powers to of a civil court in case of such disobedience or breach of injunction is not to be exercised as an alternative. The only element which is required to be seen that such powers are to be exercised as a matter of discretion, as the expression may, I mean, by invert, has been used. Now, may expression may finds place in the orders passed by the learned Munsif, comma, the conclusion arrived at is supported by discussions, including the evidence of 3 numbers of witnesses. The first appellate court in the order dated 16 March 2020 has also made adequate discussion on the relevant facts and circumstances. Full stop. This court has also noticed that the learned Munsif has also taken into consideration the fact that the petitioner is a woman, and therefore 7 days of detention in civil imprisonment has been directed. Full stop. This court is of the view that exercise of such discretion appears to be done in a reasonable manner. Full stop. Even otherwise, comma, the revision powers, even otherwise, comma, the powers vested on this court by Article 227 is supervisory in nature, and the orders of the subordinate court are not to be interfered in a routine manner unless there is an issue of jurisdiction or the orders passed are palpably erroneous. The instant case, however, does not. In the instant case, however, it does not reveal that there has been any error of jurisdiction, and the relevant factors appear to have been taken into consideration. In that view of the matter, this court is of the opinion that there is no merit in this petition, and accordingly, the same is dismissed.
Obliged.
MS S. Chakraborty. Who is S. Chakraborty? Sangeeta Chakraborty. None appears for the petitioner on call. In the interest of justice, placed on Friday night or on Monday night. It's the release of the
Made present option.
Yes.
Well, this matter touches upon the aspect that after a mediation process and the part in the honorable court, when the parties to the proceeding, husband and wife, agreed to divorce each other.
Oh, that.
Yes, and the report was drawn.
Yes.
The judgment of the apex court we have but there will be slight departure in this matter.
You are the husband.
Husband. Relevant would be 21 and 27.
No, there is another.
This is also by no, there was another one. I took the printout the other day. But this is the same issue. It will deal with the same issue. The difficulty in this case is it deals with just the Amardeep Singh case. And paragraph 21, if Lordship may-
Yes, please.
Justice Goel's judgment I've gone through.
Hmm.
I took the printout, I somehow misplaced. Anyways, the factors mentioned in Amardeep Singh versus Harveen Kaur Supra in paragraph 19 are illustrative and not exhaustive. These are factors which the court is obliged to take note of. If all the four conditions mentioned above are fulfilled, the court would necessarily have to exercise discretion to waive statutory waiting period under section 13(b)(2) of the Marriage Act.
Yes.
This refers to the conditions at page 9, paragraph 19.
Yes.
Lordship is there. The
Yes,
four
sir.
conditions. Number one, the statutory period of 6 months specified in section 13(b)(2), in addition to the statutory period of 1 year under section 13(b)(1) of separation of parties, is already over before the first motion itself. I do not fall under that. All efforts for mediation, conciliation, including efforts in terms of Order 32A, Rule 3 CPC, Section 23(2) of the Act, Section 9 of the Family Courts Act to reunite the parties have failed, and there is no likelihood of success in the direction by any further orders. It has not failed, it has reached a conclusion rather.
Hmm. Yes.
3. The parties have genuinely settled their differences, including alimony, custody of child, or any other pending issue between the parties. Yes, but in a different context. We chose to move out, not to stay. The waiting period will only prolong their agony. Correct. Now, it says if all the four conditions mentioned are fulfilled. Now, here we have put up the Amardeep Singh interpretation would say if all the difficulty here is in that case or any case, whenever his application is filed before the family court and these conditions are presented, then a waiver concept would come. At paragraph 27,
But these are all these are illustrative in nature.
the illustrative in nature, but
not
27,
Yes.
27 would show.
Yes.
May I read?
Yes, please.
For exercise of the discretion to waive statutory waiting period of 6 months for moving the motion for divorce under section 13(b)(2) of the Hindu Marriage Act, the court would consider the following amongst the other factors, so and so, so and so and so. These were given 8. Now this comes in the realm of directions, therefore would be binding. Now, in a
When was your marriage?
Fine. The date of marriage is 12th of March 2018.
12. See. You have any issues?
No,
When did you institute the divorce proceeding?
but that is 21.
21.
That was the divorce proceeding, restitution of conjugal rights from the husband side.
When did you institute?
2021 FC civil case number 212 of 2021.
By you,
Yes, yes, by the husband.
or your husband, for
Restitution of conjugal rights.
11.
212
No. Section 11, section 9.
99.
Section 9. Restitution. Yeah.
Now the wife filed an application in this honorable court, transfer petition C 15 of 22.
Uh,
Petition C number 15 of 22.
15 or 22 for transfer from
Here to North Lakhimpur.
where you instituted where? Guwahati.
I instituted Guwahati, family court Guwahati, Kamrup, Guwahati. Again, wife had initiated a proceeding, miss case number 78 of 2021 under section 125 CRPC, CJM, North Lakhimpur.
Which case number?
78 of 2021,
Under 125.
125 CRPC at North Lakhimpur. In the Honorable High Court, in the transfer petition, the parties chose to go for mediation.
Understood.
The report is there. It was decided we'll part ways, 5 lakhs to be paid. First, 2 lakhs or 2 lakhs on the initiation of the mutual proceeding, and in the last day, 3 lakhs. And all whatever street hunt we had given up. This is on record. Now, a joint application was filed before the family court.
And the rest 3 lakhs you have paid.
Yes, entire 5 lakhs on the first day. They also acknowledged, the wife also acknowledged that in the joint petition. That was filed on 17th of February 23. The joint petition by the husband and wife.
Okay.
Paragraph 8 at page 21. The relevant conditions, preconditions are there.
Case 21.
Page 21, paragraph 8 of the joint application. That the petitioners state that they have been separated and living separately for more than 3 years prior to date of filing this petition. That the
Where
parties,
we're reading page 21.
page 21, paragraph 8, the first one.
Yes.
That the petitioners state that they have been separated and living separately for more than 3 years prior to the date of filing of this petition. That the parties have already withdrawn all the pending cases, that is FC civil case number so-and-so in the Court of Principal Judge Family Court number 1 at Kamru. Miss
Yes,
case
sir.
number so-and-so, Court of so-and-so.
Hmm.
Lakhimpur also, after settlement of the dispute by mediation so-and-so in transfer case so-and-so before this honorable court. Now, that the petitioner number 2, that's me, has agreed to pay 5 lakhs as permanent so, and the same was paid.
Paid.
Right, so-and-so, 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 and the petitioner number 1 has no other monetary claim for number 2. So far. Now, my lord, so far as the apex court judgment is concerned, in our case, in the same issue was slightly departure. This is for, if I may invite panel's attention to the Guwahati High Court mediation rules. I make pass on that.
Where is the order of this court? In the proceeding, transfer.
That was closed on withdrawal. We did not annex. No? If we can just produce it. Let's just close in view of this.
That mediation report was.
Mediation report is here.
No, it was taken into consideration.
Yes, 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 yes.
Is there any reflection in the judgment in the order?
Yes, it is there.
Let us see.
I can produce a printout copy after some time. We did not annex because the matter was closed. We filed a joint petition there. We can produce it. At two.
But I think that will be good.
Yes, at
We'll refer it and we'll dispose it.
yes. At two. Only the difficulty comes in because under the civil procedure mediation Guwahati High Court rules, it is a direction to pass a decree after a mediation. Now, we have not approached the first time. Prior to that, under the mediation rules, which is under Article 225 and Part 10 CPC and Article 6 of Assam High Court's order, this has a different connotation altogether. So if an application is filed preceded by a mediation of an honorable court, High Court,
No,
then-
we may not go into those.
no, I'm just pointing out.
No, we may not go because we need to see the facts and
Yes, yes.
circumstances
We'll point out. At
for a court to consider waiver of the 6 months.
Lordship.
And in this case, we find that the facts and circumstances are suitable
Suitable.
for by waiving this period. This is nothing but prolonging the.
We had a difficulty because every day we are paying 4,000 to the wife. Obliged. At
Come at 2 o'clock.
Lordship.
No, this is a take a rejection of an amendment application, my lord. If your lordship will see, my lord, that the order is at page 87, my lord.
Order.
87 page.
You are who?
My lord, we
Who
are
are
the
you?
plaintiffs, my lord.
Petitioner is the plaintiff.
Yes.
Suit for
Suit for, my lord, eviction, my lord.
eviction. Ejectment or eviction.
Eviction from the left, my lord.
Land.
My lord, here, if your lordship comes to page 87, my lord,
You instituted the suit.
my lord,
You had instituted the suit.
my lord.
Then what did happen?
Suit was dismissed. Suit was dismissed, my lord, then we prepared an appeal.
to dismiss.
Then we prefer the appeal.
It preferred.
Yes.
Thereafter,
Thereafter, in the appeal, my lord, we filed an application for amendment of one of the pleading, my lord. It was typographically wrongly
pleadings,
typed.
the
My lord,
pleadings of,
our pleading.
pleading where? A memo?
It
It
is Suit,
is suit.
suit, my lord. My lord, what happened? Only date of birth of our mother, my lord. Date of death of our mother, father has been shown as 13/2/2003, which should have been 13/9/2003. That is the only thing. Except that nothing is there, my lord. The death certificate has been exhibited. Our evidence is there. Evidence is also 13/9/2003. Everything is there. But only technical, my lord, nothing more than that.
Can it be done?
My lord,
Appellant is
my lord, any stage, my lord, it can be done. Only thing, my lord,
after, you say after the trial begins,
my lord,
now suit has been decreed.
my lord, that is correct, my lord. But even then, my lord, because if your lordship see, the death certificate has been exhibited.
No, that is okay, but you did not take the due diligence.
No. Due diligence,
You
my lord,
you could have gone for correction of the decree, not for amendment.
my lord.
You could have gone for a correction.
Look, there is a correction, my lord. Virtually, my lord, there is correction. Virtually correction, my lord. Because technical, my lord.
Let us see your application. Okay, we'll come back.
My lord. It says this was held that if granting of amendment
2000?
2004, 6, SCC 4 and 5. my lord.
2004.
And it was relied on in 2012 also, my lord. That also reference it there. I found it, my lord. Amendment really substance the ultimate cause of justice and avoids further litigation. The same should be allowed. In the same decision, it was held that the amendment taking declaration that title shall not introduce a different relief which necessarily factual basis has already been laid down in the plain in the court of fellows. We reiterate that amendment necessary for the purpose of determining the real question of controversy in the parties should be allowed if it does not change the nature of the suit. A change in the nature of the relief claim shall not be considered as a change in the nature of the suit, and power of amendment should be exercised in larger interest of doing full and complete justice between the parties, my lord. My lord, in some exceptional cases is there, my lord. It's not that some places are there, that's correct. But only thing, my lord, here the evidence is there. It is 13/9/2003, my lord, date of death. The document, my lord, original document is there, my lord, in the record. That death certificate. That also shows 13/9/2003. Only in the plain, my lord, that has been wrongly cited, my lord.
What was type?
13/2, my lord, in place of 13/9/2003. 13/2, my lord. This is the only, my lord, correction we wanted to make, my lord.
Now, how
Well,
is it making?
Some places are there, my lord.
Now, how is it making any difference to the suit?
My lord, only thing, my lord, the courts are, my lord, giving more stage because you cannot lead evidence different to that of the pleading.
No. How is it relevant? The date of death?
That of that is relevant because a gift deed has been, my lord, made in the month of August. That is why, my lord. August, no? 7th August, my lord. That is why, my lord, it is relevant. So it will not change anything, my lord, because the original document is there, my lord. That's why, my lord, I am.
But the entire defense will be shattered.
My lord,
Entire defense will be shattered.
no defense will
The
not be.
defense which they
No.
have taken. That
Ev-
is,
Evidence, but the document is there, my lord. Evidence and document is there.
but aren't we affecting, causing prejudice to them in their defense?
No, not at all, my lord. No. It is not possible. If necessary, my lord, I can place, my lord, day after judgment. If necessary. And document the evidence is the main evidence, my lord, virtually.
Sorry, we are dismissing.
My lord,
Dismiss. third James Learned Senior Counsel for the petition assisted by MS2D. The powers of under Article 227 of the Constitution of India, read with Section 151 of the CPC, is being thought to be invoked in this petition, where a challenge has been made to an order dated 15/2/2023, passed by the learned additional district judge, Dibrugarh, whereby the petition bearing number 4716 of 2017, filed in title appeal number 1 of 2018, has been rejected. Full stop. The aforesaid petition was filed under Order 6, Rule 17, read with Section 151 of the CPC. Full stop. The petitioners were the plaintiff and the suit was filed for eviction. Full stop. The suit being dismissed, comma, the suit which was registered as title suit number 18 of 2008 was, however, dismissed by the learned Munsif number 1, comma, Dibrugarh, whereafter the appeal was preferred, being title appeal number 1 of 2018 before the learned additional district judge, Dibrugarh. During the pendency of the appeal, comma, the aforesaid petition number 4716 of 2017 was filed for allowing amendment of the plaintiff in exercise of powers under Order 6, Rule 17, read with Section 151 of the CPC. Full stop. The Senate Court, by the order dated 15/2/2023, has, however, dismissed the state petition. Full stop. Sri Sayola, the Learned Senior Counsel, has submitted that the amendment sought for was of trivial nature, where the date of death of the mother of the plaintiff, father of the plaintiff, was wrongly typed as 13/2/2003, which was actually 13/9/2003.
Yes.
He has further submitted that the documents which were filed in support of such death, in the support of such fact of death, contains the correct date as 13/9/2003, and therefore it was in the fitness of things that the amendment should have been allowed. Full stop. The Senior Counsel has also referred to a decision reported in 2004, 6 SCC 415 on the powers of the court to grant amendment. Full stop. Para. The provision in the CPC regarding amendment of pleading is found in Order 6, Rule 76, which is expected herein below. Full stop. The state provision gives the power to the court to allow a party to amend his pleadings at any stage to so as to determine the real question in controversy between the parties. Full stop. However, there is a proviso to the aforesaid Order 6, Rule 17, as per which, no application for amendment is to be allowed after the trial has commenced, unless the court comes to a conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. In the instant case, it is not in dispute that not only the trial had begun, the suit itself was dismissed, and it is only at the appellate stage that the application was filed for amendment. Full stop. The proviso makes it clear that amendments are not to be allowed after the trial has commenced, and such amendment can be allowed only under exceptional circumstances where, in spite of due diligence, the party could not have raised the matter before the commencement of trial. In the instant case, though it is submitted that the amendment sought for is trivial in nature, it transpires that a defense has been taken by the adverse party in the suit with regard to the gift deed, which is executed on 7/8/2003. In the considered opinion of this court, the amendment sought for would be hit by the proviso of Order 6, Rule 17, and no exceptional circumstances has been able to be made out, and rather allowing the amendment at this stage would be causing prejudice to the defendant on whose stand, an interpreted order has been passed by the trial court dismissing the suit, which is the subject matter of the appeal. In that view of the matter, the interpretation is dismissed.
Judicial, I am appearing for FIR number 3 and 4. Lord.
You're there.
Yes.
3 and 4 are state.
Third, Lord.
Um,
Third and deputy.
Leaders for state council. 4 is 1 of 3.
It is the matrimonial appeal against the judgment and directive passed by the Larner District Judge Withdrawal, dissolving the marriage between the petitioner and the opposite party and awarding an alimony of rupees 20 lakhs. We have coming against the alimony. The appellant husband has filed a petition for divorce against his wife on the ground of mental cruelty. The Larner trial court, after recording evidence of both the parties, it was found that the torture caused on the husband was proved. That is why marriage was dissolved. But he has awarded alimony of rupees 20 lakhs without assessing the income of the petitioner, my lord. The petitioner, he has no capacity to pay that 20 lakhs alimony because the 10,000 has already been paid since 2014 as maintenance, my lord. Actually, he was the.
That was penalty life.
My lord.
That was penalty life. 10,000 was penalty life. 10,000 per month was during the pendency of the
Yes,
proceedings.
yes.
Cannot be a permanent alimony.
That is that is by way of maintenance, my lord, since 2000.
Now this is 20 lakhs is a permanent alimony, isn't it?
Yes, it is permanent alimony now. It is now permanent alimony. But permanent alimony, I got the quantum is high, my lord. Your lordship kindly see that he was the diploma holder of the alternative medicines, my lord. Earlier, he was working in a tea garden, my lord. Only 8,000, 12,000 income, my lord. Your lordship kindly see the page 66, annex of 4 colli.
Oh.
Page 66, this was the income.
Just
It was Salna tea company. He was paid rupees 20,000 and 8,000 around. That is 12,000. 12,000 plus 8,000, total 20,000, my lord. And in the year 2012, he has received rupees 15,000 in Masbat tea estate, my lord. Now the Solva tea estate, he has been received rupees total 20,000. 2004, the 6,000, my lord. And now, my lord, page 71, the Hograjuli tea estate, there he has been paid rupees 8,000 plus, and that is 8,000, my lord, in 2006, my lord. And now,
okay, you
again,
have to make a deposit. How much deposit are you going to make?
my lord.
You have to make a deposit. We'll admit this.
Huh?
We'll admit this, Mr. Sharma, but you have to make a deposit.
Now it was not deposited, my lord.
No, you have to make a deposit
That,
as a condition.
that means we have come for a reduction of the amount, my lord.
That is it. We will consider your case, but now presently you have
Now,
to
if you're not say, I think 1/3 we may deposit, my lord. 1/3 of the amount, my lord.
20 lakhs. You deposit how
No,
much?
no, in the total quantum was granted by the 20 lakhs. After 20 lakhs, if we are given the 7 lakhs, that is 1/3, we'll deposit it. Beyond that, we have no capacity because now I am not in the garden job. I'm in
No,
the,
we'll definitely examine your.
I'm working in the medicine company.
Understood. Now we'll examine your case, but till such time you make a deposit of rupees 7 lakhs in this court. Yes.
My lord, people. My lord, may I say? My lord, 50% may be deposited because till from 2022, from the date of judgment, nothing have been paid to me, lordship. And our 16 years old boy is with me, and he's school going. So 50% maybe.
You have a son of 16
Yes,
years.
for the son and daughter.
Or daughter is also there.
Son and wife. my lord.
So son.
Now, my lord,
Only son.
one thing your lordship would have to consider, the judgment page 33, my lord, I read out,
Presently, what do you do, Mr. Sharma?
my lord.
What do you do presently? Presently, what do you do?
No, presently by permission, the appeal may be admitted.
No, no. What do you do? What does your client do?
Now,
How is he employed?
that is,
Presently, what is the job of your client? Where is he working?
presently he is doing in a medicine company, my lord. He is doing 20 to 25,000. He has parents also. He has all parents. He is to maintain it. He is the only son, my lord.
Sri K. Sharma. When it comes for the appellant who is aggrieved by the part of the judgment and order dated 36/2022 passed by the London District Judge Udalguri entitled to divorce number 26 of 2016, whereby alimony, permanent alimony of 20 lakhs has been directed to be paid in 3 equal installments within 3 months. Full stop. The said judgment has also dissolved the marriage by decree of a divorce. Full stop. Sarah? Sri Sharma, the learned counsel, has submitted that there was no proper assessment of the income of the appellant before such alimony was granted. Full stop. Admit. Call for the record. Admit. para. The LCR hygienic has already been received pursuant to an order dated 2/6/2023. Full stop. Three, your name?
R Islam.
The R Islam Senate Council has appeared for the sole respondent, and therefore there is no requirement of taking any further step. You have got a copy? Full stop. List after 6 weeks for orders. You have filed any IA
I have file করেছি I have file করেছি নাকি
or stay?
সেই কারণে I have file করেছি নাকি সেই কারণে I have file করেছি নাকি ওড়িশা
No.
You have to file an IA. In an appeal, we cannot pass an interim order. These are statutory appeals. You have to file a IA. File an IA. The Islam Miscellaneous Council for the petitioner submit that no amount has been paid till now. Full stop. This court in the earlier order dated 2/6/2023 has already observed that the respondent would be at liberty to file appropriate petition before the learned court in this regard. Full stop. The state option may be availed of. Full stop.
Now I am to pay my lord. How much I am directed to pay now?
Right now, nothing, because we are not staying. Unless you pray for stay, we'll pass a condition.
Then my lord. Then is too hard.
Not then. Unless you file an application for
I have
stay,
file করে
we will not stay. There is no question of stay. You file an IA, we'll direct you to pay around 8 lakh. File it immediately. You file execution.
I have file করে বলেছি
Obliged.
At all line. Sri Sharma, the Learned Council, submits that he may be given liberty to file appropriate IA for stay. Full stop. The parties are at liberty to file such IA.
I will file I am.
Okay.
Made picture. In this petition, my lord, challenge has been made against the order of the 3822, which is at page 30.
Other side has appeared.
Other side, my lord, notice has been served, justice has been, my lord, made, my lord, affidavit also, my lord, filed to that effect.
You have taken dusty also.
Yes, ma'am. Here in this case, my
Just a
lord,
minute. Madam, are you for?
I'm for government, your lord, respondent number 3 and 4, your lord. We have filed our reply, your lord, affidavit, your lord.
Who is 1 and 2? Mr. Sharma?
Right.
1 and 2 is against them, my lord. I have sought a decree, my lord. They are private persons, my lord. One is my brother, my lord. Another is my lord, who is possessing my land. Who is brother?
Petitioner is the plaintiff.
Petitioner is the plaintiff. He filed a suit in relation to the mother schedule B and C land. Schedule B comprises for mother right to declaration of right to
Declaration.
interest, yes, and recovery of pay. Recovery of pay.
For a plot of land. Recovery of plot of land.
Plot of land.
Then what happened?
My lord,
Suit was contested.
Suit was contested. My lord, government did not file any written statement in that
Government was a party.
was a party. Notice under section
The
81.
private respondents said
They have stated, they have
Contested.
submitted a written statement.
the previous private defense. No,
My lord, only one has filed, my lord, written statement. Two did not file.
okay, then what happened?
My lord, trial has commenced.
Bad comment.
My lord, I have, my lord, submitted my evidence in chief, my lord. I was cross-examined, my lord. And during the, my lord, course of the trial, my lord, I filed an application under order 23 rule 1 my lord, for withdrawal of the suit.
For
Withdrawal of
Withdrawal.
the suit.
order 23 rule 1.
Right.
Why
Thus,
withdrawal?
withdrawal, my lord, some formal defect was there, my lord, and some, my lord,
Formal defect.
my lord. And some other grounds are also there, my lord.
Yes, thereafter
But after hearing the parties, that was dismissed, my lord.
dismissed.
Against that, my lord,
Dismissed on 3-8.
3-8. my lord.
Petition dismissed.
Right.
Yes.
Now, my lord, so far the, my lord, contents made in the petition seeking withdrawal, my lord, that is to be looked into first, page 28, my lord.
2-8.
Earlier, my lord, the suit was conducted by one set of advocate, my lord. Subsequently, he was substituted. A new set of advocate was engaged. The new set of advocate has, my lord, filed this petition. Annex 3, page 28.
28.
28.
Rule 1-3. Rule
Right.
1-3.
My lord, rule 1. My lord, I sought a liberty to, my lord, withdraw, liberty to file a spread.
Please read order 23 rule 1-3.
My lord, order 23 rule 1, withdrawal of suit or abandonment of part of claim. At any time after the institution of a suit, the plaintiff may, as against all or any of the defendants, abandon his suit or abandon a part of his claim, provided that where the plaintiff is a minor or other person to whom the and this part is not relevant to us. 3, my lord, where the court is satisfied that a suit must fail by reason of some formal defect, or that there are sufficient grounds for allowing the plaintiff to institute a fresh suit for the subject matter of a suit or part of a claim, it may, on such terms as it thinks fit, grant the plaintiff permission to withdraw from such suit or such part of the claim with liberty to institute a fresh suit in respect of the subject matter of such suit or such part of the claim. Where the plaintiff abandons any suit or part of claim under subrule 1 or withdraws from a suit or part of a claim without the permission referred to in subrule 3, he shall be liable for such costs as the court may award and shall be precluded from instituting any fresh suit in respect of subject matter or such part of the claim. 5. Nothing in this rule shall be deemed to authorize the court to permit one of several plaintiffs to abandon a suit or part of a claim under subrule 1 or to withdraw under subrule 3 any suit or part of claim without the consent of the other plaintiff. So far, Rule 3 is concerned, my lord. I have, my lord, prayed for leave, to allow me to withdraw the suit to file a fresh. Basically, I have stated the ground.
See, rule 3 has two parts.
Two parts, my lord. One is, my lord,
That
formal
the
defect,
suit would fail by reason of formal defect.
my lord,
And the second is sufficient cause,
sufficient.
which would probably has been left to the discretion of the court.
Court, my lord.
You have to satisfy the court that that there are sufficient reasons for allowing you to institute a fresh suit
My lord,
by withdrawal of this.
my lord,
Now, how was your petition structured?
my lord.
Let us see page 28.
Page 20. May I read it? That the plaintiff has newly appointed Mr. Vijay Kumar Sodri as his lawyer to conduct his case. That after handing over the case record, a newly engaged advocate gone to the plaintiff and found that there are some formal defects
Defect.
in drafting the plaintiff itself. That the whole plaint reflects that there is some ambiguity in describing the whole suit land. Second part. That in paragraph 3 of the plaint, it has been stated that plaintiff got another 1 bigha land from DAG number 225, but it is not clearly stated from where plaintiff got his 1 bigha land. In the same paragraph, the plaintiff has submitted that there was an exchange of land between plaintiff and the defendant number 2, but it has not been stated clearly which portion of land was exchanged between the plaintiff and defendant number 2. That the aforesaid ambiguity cannot be corrected by way of amendment at this stage. That due to the lapse of specific description of land, it can be stated that there are some formal defects in the plaint. That due to the aforesaid formal defects, the plaintiff intends to withdraw the suit with a permission to file a fresh. Madam, so far, this contention is there, madam, basing on which, madam, the learned trial court below has made an observation that whatever the statement or the grounds shown by the petitioner is reflected in the paragraph 3 of the plaint. Before, my lord, going to paragraph 3 of the plaint, if you lordship permits to go to annexure for impugn order, page 30, my lord.
30.
30.
Yes.
May I read?
3.
30, my lord, 3822, my lord. Plaintiff is represented by the newly engaged counsel and the Vokalatnama is submitted. Defendant side also is also duly represented. Today was fixed for order on petition number so and so. The newly engaged counsel verbally stated they do not have any submission to put forward regarding the aforementioned petition. Petition number 23021 is preferred by the plaintiff side under order 23 rule 13 of CPC. The plaintiff has submitted that he has engaged new counsel to conduct his case, and on going through the case record, the newly engaged counsel found that there are some formal defects in drafting the plaint itself, which reflects the ambiguity in describing the whole suit land. It is stated that the paragraph 3 of the plaint, it is mentioned that the plaintiff has got another 1 bigha of land from DAG number so and so, but it is not clearly stated from where the plaintiff got the said land. In the same paragraph, it is also mentioned that there was an exchange of land between the plaintiff and the defendant number 2, but it has not been stated clearly which portion of land was exchanged. It is further stated that the aforesaid ambiguities cannot be corrected by way of amendment at this stage. Also, due to the lapse of specific description of land, it can be stated that there are formal defects in the plaint, hence the plaintiff has paid to allow them to withdraw the suit with a permission to file a fresh suit. The defendant side verbally objected the aforementioned petition, stating the plaintiff has submitted the evidence in C of 3 numbers of witnesses, and accordingly PW1 has already been cross-examined. It is further stated that the vital part of the evidence is already completed, and at this stage, the prayer shall not be allowed as it will cause prejudice to the defendant side. A bare appraisal of order 23 rule 13 of CPC provides that a suit may only be withdrawn with the permission to bring a fresh suit when the court is satisfied that suit must fail for reason of some formal defect or that there are some other sufficient ground for allowing the plaintiff to issue a fresh suit. The power to allow withdrawal of a suit is discretionary. Now it is opposite to mention that the Honorable Supreme Court in so and so reported in 2017 5 SCC 53 has held that formal defect is a defect of form prescribed by the rules of procedure. For example, want of notice under section 80 of CPC, improper valuation of the suit, affixing insufficient court fee, ambiguity regarding identification of the suit property, misjoinder of parties, failure to disclose the cause of action, etc. It was further observed that formal defect must be given a liberal meaning, which connotes various kinds of defects not affecting the merits of the plea raised by the either parties. In the present case, it is submitted that the previously engaged counsel for the plaintiff while drafting the plaint has stated that the plaintiff has got a plot of land measuring 1 acre under DUG number 225, but has failed to give specific description of the said land. On perusal of the case record, it appears that the plaintiff has asserted in paragraph number 3 of his plaint that he got 1 acre of land under DUG number so and so of the same village from the land left by his deceased mother. And after exchanging the said 1 acre of land with defendant number 2, he has acquired a total plot of land measuring 10 acre 2 lessa out of the Schedule A land. Hence, it was well within the knowledge of the plaintiff as to where from he has acquired the said land, and with due diligence would have mentioned the specification of the said land in the plaint. Plaintiff has further stated that the newly engaged counsel, while going through the plaint, has found that there are some formal defects in drafting the plaint. If that is to be held, then perusal of the case record reveals that Mr. Vijay Chaudhary, the then newly engaged counsel, had filed the Wakalatnama on 2012-2019, and the instant petition was filed on 11/2/21. At much later stage after the cross-examination of PW1. In view of the aforesaid discussion, I am not satisfied with the plea of the plaintiff side that the suit suffers from a formal defect. Rather, I am of the opinion that the plaintiff is trying to fill up the lacuna of his case and allowing the prayer of the plaintiff would cause prejudice to the defendant side, affecting the merits of the plea. Thus, petition number so and so is rejected. This is the order, madam, passed by the learned trial court. So far, madam, this observation is given by the learned trial court below. Firstly, my submission before Lordship that so far, madam, engagement of the initiative advocate is concerned. Wakalatnama was filed on 2012-2019. So, my lord, after 19, my lord, I have, my lord, recorded the dates when it was fixed, my lord. Only after passing of 4 dates, my lord. Till, my lord, start of the COVID, my lord, situation. 10/1/20, 6/20, 29/20, and 21/3/20. During that period, my lord, leaving that period, my lord, other parts have been, my lord, at the time of COVID situation, my lord, it has been passed without any formal order. Apart from that, my lord, so far the petition of withdrawal is concerned, it can be, my lord, filed at any stage, even at the stage of, my lord, second appeal. There is no bar so far that part is concerned, my lord. So engagement of an advocate, and subsequently after leaving 4 dates, lapsing of 4 dates, he has filed this petition. That cannot be, my lord, the ground for rejection. But so far the grounds, he is, my lord, filing the petition at the later stage, showing the reason that he could not go to the records. That may be taken into consideration by this honorable court, as because, my lord, he has taken the brief and he has filed his Wakalatnama, he may not, my lord, go to the record, my lord. Although it is presumed that on the day of filing Wakalatnama, he has gone to the records, my lord. That about, my lord, the another point, so for the learned trial court has, my lord, stated the description of, my lord, suit property has been specifically mentioned in paragraph 3 of the plaint. And so for exchange part and, my lord, exchange gifted part is concerned. If you also kindly take into consideration the paragraph 3 of the plaint, which is at page 13, my lord.
1-3.
1-3, my lord. This is the basic paragraph, basic on which, my lord, the petitioner, is the plaintiff, has claimed his right capital and interest.
Page 13.
Page 13, paragraph 3, my lord. May I read it out?
Yes.
That out of the said 46 bighas of land, this 46 bighas of land is my lord, inherited from father's man. A plot of land measuring 14 bighas, 3 kothas covered by Dag number so and so and Medivatta number so and so village so and so, as described in Schedule A of the plain, had been partitioned amongst the plaintiff and the defendant number 2 and daughter of deceased, namely Sambuli Khatun. Thus, the plaintiff got a plot of land measuring 7 bighas, 2 kothas, 14 lasas of land out of the said 14 bighas, 3 kothas land. Moreover, the plaintiff also got further 1 bighas of land under Dag number 225 of the same village from the land left by his deceased mother. Subsequently, defendant number 2 and the plaintiff made an exchange of land between themselves. Thus, the defendant number 3 to deliver defendant number 2 delivered possession of land measuring 3 bighas under Dag number so and patta number so to the plaintiff, and plaintiff delivered possession of land to the defendant number 2 measuring 1 bighas of land as stated above. Now, my lord, this is the lines. These are the lines, my lord. 1 bighas of land under Dag number so of village, same village from the land left by his deceased mother. Only this statement has been made in respect of, my lord, land donated by his mother to the plaintiff. Inadvertently, my lord, when it was, my lord, donated, and what was
What is the line? Moreover, the plaintiff has got further 1 bigha of land under Dag number so and so of the same village from the land left by his deceased mother.
Right.
There is no question of any gift deed or something.
my lord,
You have not pleaded.
my lord, got further 1 bighas of land. How
Yeah.
he has got, my lord, that is the my petition reflects that he has stated that 1 bighas of land has been got from his mother. How it was got, either by way of gift or some other else,
This is a formal defect.
and that I am going to that. Apparently, my lord, what happened, my lord? So for his land under his possession and under his title,
See, Mr. Sharma,
my lord,
we are on a supervisory jurisdiction. We may
Right.
not go deeply into the facts.
Right.
You have to show, make out a case that order 23, rule 3, the conditions have been fulfilled. The rejection, the dismissal of your petition has been done by without taking into consideration the relevant facts and circumstances.
Right.
If you can make out a case, we may. Otherwise, our jurisdiction under revision or supervisory jurisdiction to 227 is absolutely limited.
That's
Unless there is an issue of jurisdiction, error of jurisdiction, or exercise of jurisdiction not conferred by law. It is there is no averment or there is no dispute that the learned court has the jurisdiction to consider and pass appropriate order.
Right.
The only avenue which you have is that the discretion exercised by the court has not been done by taking into consideration the relevant facts and circumstances, or irrelevant facts have been taken into consideration. Only on this two aspects. Otherwise, we will be very low in.
that's true, my lord. So for this line, I have mentioned because of the fact that learned trial court has my lord, relied upon and stated that since the petitioner has mentioned specifically in the said paragraph about this particular 1 bighas of land.
And what about the observation by the court that you are cross-examined? Now their defense is open.
But that is not observed. In the impugn order, so far my evidence part is not discussed.
You have not been cross-examined.
I have been cross-examined, but so far what was happened
Now,
during the cross-examination,
if
that
you are
was,
cross-examined, their defense is out. Now, if you are
my lord,
allowed to file a fresh suit,
Man-
then you fill up the lacuna. That is not the
no, my
purpose.
lord, that is not, my lord.
Okay, at 2 o'clock, we'll let.
My-
Yes, Mr.
my lord. Now, my lord, the learned trial court below has also my lord, relied upon the decision the reported in the 2017. I have gone through that decision, my. Yes.
So 17.5 is this.
My lord, 2017 5 Here in that case, my lord, so far my lord, correction of the survey was my lord, concerned, my. It was filed.
Just,
Ma'am.
just yes, yes.
My lord, in that case, my lord, at the time of my lord, pronouncement of judgment, my lord, petition for withdrawal was filed. Accordingly, my lord, that was my lord, the long run, my lord, approach the honorable apex court, my lord, in para 11, my lord. So far, the discussion has been made in relation to order 23, my lord,
Paragraph 11.
paragraph 11. Prior to that, my lord, it starts from actually from para 8
Hmm.
regarding order 23, my lord. Para 8.
Hmm.
Married.
Yes.
But in terms of order 23, rule 13B, where the court is satisfied that there are sufficient grounds for allowing the plaintiff to institute a fresh suit, the court may permit the plaintiff to withdraw the suit. In interpretation of the word sufficient grounds, there are two views. One view is that these grounds in clause B must be adjusted generis with those in clause A, that is, it must be of the same nature as ground in clause A, that is formal defect or at least analogous to them. And the other view was that the word other sufficient grounds in clause B could be read independent of the word as formal defect and clause A. Court has been given a wider discretion to allow withdrawal from suit in the interest of justice in cases where such prayer is not covered by clause A. Since in the present case we are only connected with the formal defect and this is under clause A, rule 1 sub rule 3, we should not to elaborate any further on the ground contemplated under clause B that is sufficient. And so far, my petition is concerned. I have mentioned regarding my not describe the right, my right and title about which I have acquired from getting some portion of land. That my lord, I want to my lord place before the learned trial court below for adjudication. That apart, my lord, so for the actions part is concerned, my lord, although my lord, it was the findings of the learned trial court below that I have specifically mentioned, my lord, whether that part was part of land was my lord inherited within the my lord schedule A land, which is also my lord composed of my lord inherited land. And so far, my lord, I have also my lord, made discussion with my client directly, my lord. And I have getting some information from him that my lord, what happened, my lord, some instruction, though my lord given, my lord, that was not placed in the suit. Not only for the ends of justice, he wants to place all these things, my lord, by filing a fresh suit. And so far, my lord, cross part is concerned, and the trial part is concerned. At the stage of my lord, at any stage, it can be filed, my lord. And so far, my lord, the objection raised by the other side is concerned, my lord. They have stated that they are in possession of schedule B and C land, whereas my lord, in prayer portion.
You have the order by which this notice was issued in your petition. Order dated 16/11/2022 by this court.
It is,
By this court. Do you have a copy of the order?
my lord, I have not gone through my lord the report. I
Now,
am
while
actually newly
issuing-
engaged, my lord.
While issuing notice,
My lord,
this court on your interim prayer has observed that I'm reading the paragraph for you.
my lord,
Senate counsel for the petitioner has prayed for stay of the proceedings of the suit by projecting that in the plain, the petitioner had not given correct description of the suit land
Right.
and has also not defined the exact boundaries of the suit land which was exchanged with his sister. Hence, it is submitted to the suit suffers from defect of substantial nature.
substantial necessary, I have gone to the plain, my lord. And so
No,
far,
substantial nature defect and formal defect are
that's
totally different
Different.
connotation.
totally different.
Formal is something which is on the face of it,
My lord, and so far the formal part is concerned, my
but
lord.
this is a defect which has gone to the root.
Right.
And your examination, cross-examination is already over. Now, allowing you to withdraw the suit with liberty to file afresh,
My lord.
won't it amount to causing grave prejudice to the other side?
My lord, so far that part is concerned, my lord. Even if you also taken into consideration regarding
You
my
could
prayer,
have filed a petition for amendment.
I could have filed my
You have not
application,
done.
my lord. So far that part is concerned, my lord.
And if you say that this is only a formal defect, you amend the plain, get it rectified. You did not take that
My
step,
lord,
number
so
one.
far, rectification part is concerned. My lord, even my lord, in prayer portion also, my lord, they would have, my lord, they would have, my lord, add. Because if you,
After cross-examination, difficult for
my
us.
lord, even my lord.
Yes, madam,
Yes,
you are for whom?
I am for respondent, government advocate, your lordship, government.
The government is a party here.
Yes, yes, respondent number 3 and 4, your lordship. 3 and 4, we have filed our affidavit, your lordship, in
You have
paragraph,
filed affidavit.
yes.
That's okay. Yes, over your part. Yes, what is it? Madam, what is it?
Paragraph number 4, your lordship, that with regard to the statement made,
There are four.
yes, your lordship,
Please read.
that in regard to the statements made in paragraph number 2 and 3, 2, 3 and 4 are denied by the respondents. The respondents clearly stated that the learned Munsif Gwalpara rightly rejected on 3/8/2022 the prayer of the petitioner for permission for withdrawal the suit with a liberty to file afresh, as the plaintiff petitioner has adduced evidence in three numbers of witnesses, and accordingly PW1 was already cross-examined. That it is stated that the vital part of the evidence has already been completed, your lordship. And paragraph number 6 also, there are some mismatch in Dag number and Patta number, your lordship.
Hmm.
And paragraph number 8 also, we have mentioned that the petitioner filed the wakalatnama on 20/12/2019, and for permission for the withdrawal of suit was filed on 11/2/2021. After cross-examination of PW1. Now the petitioner plaintiff was trying to fill the lacuna of his suit.
When
As-
was the cross-examination done? Of PW1?
My lord,
PW1 was cross-examined. on-
PW1 was cross-examined by the, my lord,
When?
that was, and I have, my lord, no knowledge about that, my
You had made a statement
lord.
regarding this point,
Cross, my lord,
which has been taken that Wakalat amount 19
my lord.
and withdrawal is of 21. You said that COVID there are 4 days only.
Yes, my lord.
And COVID has also intervened
My lord,
in the
on,
meantime,
yes,
and
my lord.
therefore you could not have filed the withdrawal application.
During COVID period only, he has filed the withdrawal petition, your lordship, 11/2/2021.
My lord,
that-
on 2012-2019, the new set of advocate has filed Wakalatnama. Thereafter, the matter was fixed on 10/1/24.
Now you have said 4 days were fixed.
Uh,
4 days.
4 days. My lord. In my lord, impugn order also, my lord, regarding cross-examination, completion of cross-examination, PWN 1 was also reflected. My lord. But when, on which date, my lord, it was completed, actually, I have not got the insight. Apart from that, my lord, so far the government's role in the title suit is concerned, my lord. The expertise order was passed against the government. Against my lord, that apart, my lord, no relief has been sought for against the government. No relief has been sought for, my lord. Even, my lord, so far, if you lordship taken into consider para 10 of the said judgment, my lord. Even, my lord, my lord, the impediment of the some prayer which may result in dismissal of the suit, that may be taken into consideration for, my lord, formal defect. Even, my lord, in 1981 also, my lord, it was also honorable apex court had made an authority. My lord, what happened, my lord, if the, my lord, even if, my lord, suit is decreed, my lord, what will happen? Even if the suit is decreed. If the suit is decreed, my lord, the basic, my lord, grievance of the plaintiff is such that some portion of land has been, my lord, forcefully possessed by them. And they have stated on the strength of one
No,
said
that's
it,
not-
my lord, that
that-
was,
that's not
I have
the
not challenged that.
That is not the consideration.
So,
The consideration is the suit must fail.
yes.
We will not go on the anticipation that if it is decreed, how do you execute
No,
the
no,
decree? That is not our lookout.
Suit will fail, my lord.
Our lookout is if the suit must fail of some formal defect.
Yes, my lord. Suit must fail, my lord, because in for non, my lord, not praying for,
Failure of your suit on merit is a different,
my lord,
has a different meaning altogether.
no, so far, my lord, my lord, mentioning the any prayer regarding challenge of that part, my lord. Again, my lord, even if, my lord, I am not, my lord, praying for any such
Sorry.
degree for precept, my lord. My lord, may I submit one thing, my lord?
We have heard you, Mr.
No, so far I am not taking adjournment, my lord. I am just praying for one thing, my lord. Even, my lord, I could, my lord, made amendment to that appeal. So
You
for what
you did not file an amendment application.
I have not
And after cross-examination, can you amend?
at any stage. I can
After
amend.
the trial has commenced.
But
What
in-
prevented you? What was the due diligence?
due
In
diligence
spite of which,
that has been shown. That has been shown by the before the learned trial court.
no, it is up to you whether you file amendment, whether it be considered. We cannot preempt now.
But
Or we application learned counsel for the petitioner who has filed the instant petition under Article 227. Where you, how can you invoke 115 and 227 together?
it was not filed by me.
Doesn't matter. You cannot say that.
My lord, I cannot say.
Article 227 of the will only say 227. Article 227 of the Constitution of India. Again, an order which is 3/8/2022 passed by the learned Munsif number 1, Walpara, whereby a petition filed under Order 23, Rule 1 within bracket 3 of the CPC in title suit number 25 of 2018 has been rejected. I have a seat, please. I will have a seat. I have also heard. I must give focus. The learned government focus. Full stop. Para. The petitioner, as the plaintiff, had instituted the aforesaid suit for declaration of right, title, interest, and recovery of possession pertaining to a plot of land. Full stop. The suit was contested by the private respondent, whereas it had proceeded ex parte against the state respondents. Full stop. It is also the admitted case that the plaintiff evidence through three witnesses were given by way of affidavit, and PW1 was also cross-examined. Full stop. However, at that stage, the application under Order 20, Rule 1, CPC was filed for withdrawal of the suit with liberty to institute a fresh suit. Full stop. Para. Shri Sharma, the learned counsel for the petitioner, by referring to the state petition filed under Order 23, Rule 1, within bracket 3, CPC, has submitted that in paragraph 2 thereof, a formal defect was pointed out, and in paragraph 3, a specific plea was taken on the ambiguity in the description of a part of the suit land. It is further submitted that though an observation has been made in the impugned order that the new set of counsel has entered appearance by filing Wakalatnama on 20/12/2019, and the amendment was sought for only on
11 to 21.
11 to
21.
21, the learned counsel has submitted that in between, there were only 4 days whereafter, due to the COVID pandemic, there were no effective sittings, and therefore it cannot be said that there was inordinate delay. Full stop. It is further submitted that in paragraph 3 of the plaint, while stating the description, there were certain details, certain details were left out, which can be termed to be formal defect. Sri Sharma accordingly submits that the order dated 3/8/2022 is liable to be interfered with. For contrast, MSK Fukan, Learned State Council, appearing for the respondent numbers 3 and 4, has submitted that affidavit in opposition has been filed on 27/6/2023, and in paragraph 4 thereof, a specific objection has been raised regarding that the plaintiff's witnesses have already filed their chief examination, and the PW1 has already been cross-examined. It is accordingly submitted that if at this stage, the suit is allowed to be withdrawn with a liberty, that will amount to giving a scope to fill in the lacunae whereby prejudice would be caused to the contesting defendant. Full stop. Sarah? Rejoining his submission, Sri Sharma, the learned counsel for the petitioner, has submitted that the stand taken by the learned government advocate cannot be relevant as no relief has been sought for from the government, and in any case, the suit had proceeded ex parte against the government. Full stop. Para. The tribal submissions made by the learned counsel for the parties have been duly examined and have been duly considered, and the materials placed before this court have been duly examined. Full stop. Para. Order 23, Rule 1(3) read as follows. While Order 1 provides for withdrawal, provides for taking leave of the court to withdraw a suit or any part thereof, Rule 3 is the proviso under which a permission to withdraw may be granted with the liberty to institute a fresh suit. Full stop. The sage Rule 3 has laid down two ingredients which are disjunctive, as would be clear by use of the expression or to interpret compound. The first condition is that the court is to be satisfied that the suit must fail by reason of some formal defect, and the alternative condition is that there are sufficient grounds for allowing the plaintiff to institute a fresh suit for the subject matter of a suit or a part of a claim. Full stop. The presence of any of the aforesaid reasons is, however, qualified by use of expression may, where the element of discretion would creep in, as even under availability of any of the state conditions, it is up to the discretion of the court to grant permission to the plaintiff to withdraw the suit or any part thereof with a liberty to institute a fresh suit. Full stop. In the instant case, though it is submitted that the plaintiff had suffered from some formal defect and there were ambiguities in the description, what transpires is that though the suit is of the year 2018, comma, such application was filed only in the year 2021 and considered on 3/8/2022, on which date the same was dismissed. Full stop. What is significant to note is that in the meantime, comma, the plaintiff witnesses had submitted directive examination by way of affidavit, and in the meantime, comma, the PW1, who is the plaintiff himself, is also cross-examined. Full stop. Thereafter, comma, filing an application under Order 20, Rule 1, within bracket 3, on the ground of the suit having formal defect does not appear to be one which is accompanied with diligence. Full stop. This court is also not impressed with the ground taken that there were change in counsel, as such change will not make any material difference with the requirement of the statute, which lays down the conditions by which such a prayer is required to be considered and disposed of. Full stop. Para. In the considered opinion of this court, comma, the order dated 3/8/2022 contains adequate reasons and discussion before coming to a conclusion that the application was not liable to be favorably considered for the petitioner. Full stop. This the learned Munsif has also referred to the case of the Honorable Supreme Court reported in 2017 5/63, wherein the expression formal defect has been explained. Full stop. Para. Sri Sharma, the learned counsel, has also laid. Sri Sharma, the learned counsel, has, however, tried to contest that the aforesaid judgment was rendered under different circumstances and therefore could not be applicable. Full stop. This court is, however, not in a position to accept the state submission, as it is only the interpretation and meaning of formal defect which has been given in the state judgment by the Honorable Supreme Court, which is material for adjudication of the present list. Full stop. Para. This court is otherwise also can otherwise also not be oblivious of the limited role to be played as a court expressing supervisory jurisdiction under Article 227 of the Constitution of India. Full stop. Unless the order impugned suffers from jurisdictional error or is palpably erroneous, comma, this court in exercise of such jurisdiction would be loath to interfere with exercise of distribution, which in this case appears to be done by taking into consideration the relevant facts and circumstances. Full stop. In that view of the matter, the instant petition.
One judgment may also be recorded, my lord. I am verifying.
You should have placed the judgment
My
of
lord. At that time, I mentioned, my lord. My lord, one prayer may be, one observation may be given. In accordance with law, my petition, any petition so far amendment.
Why
for
should we,
discussion, that
why
may be,
should
my
we
lord,
play?
in accordance.
That's up to you. We file application. If you're agreed, you come.
That may be, my lord,
We are not taking it.
obliged.
Yes. Yes.
Whether or not my lord would reflect that, but this deviation line would have been better for other cases to come also, where we go for mediation. Subsequently, it's not that for the first time we are going for a mutual divorce.
But without hearing the other side, it will be.
So this is, otherwise, I am prejudiced. Everything
No,
is,
understood,
so
understood.
let the court take a call on the next date, which is on the 17th.
No, we'll not allow the court to take a call. Court may again prolong the proceeding. Can you serve Dusty?
It will be difficult, my lord, not locking both.
No, not you, some, your client.
But for the client only, because he is in Guwahati to serve in not locking both again.
You want to dispose this of,
I understand, my lord.
directing.
Or,
We don't want to leave any discretion to the court now.
absolutely,
We want to give a direction,
Absolutely.
and to give the direction, we want who was appearing here?
D. Ghosh.
Can you,
Demonstrate Mr. Ghosh, yes, I can tell her.
you can tell her.
Then my lord would take up the matter, today is 14th. My lord will take up the matter,
Monday next?
Monday would not be available, my lord. For
Friday
17 is the date,
Friday is a holiday.
for 17 is the date fixed. Then what if lordship, an observation falls from a lordship, that on 17 we may serve to the other side and the matter may be fixed
Ah,
again
great.
on 22nd. That may be done.
Yes.
Right?
Because see, prolonging this proceeding
Absolutely.
would be the same
Same.
of having 6 months there. So unless we expedite and dispose of,
Gotcha.
part 3 as what current counsel for the petitioner. Who
We'll survey copy not to the council but to the client.
has filed this petition under Article 227. Full stop. Under peculiar circumstances, the present petition has been filed against continuation of a proceeding in the learned court of the district judge,
The family court,
in learned family court, Lakhimpur.
no, Kamrup Guwahati, Kamrup Metropolitan Guwahati.
This is in Guwahati.
Guwahati. Family court, Kamrup
Oh,
Metropolitan.
this 125 was at Lakhimpur.
Lordship.
At family court, Guwahati, in FCC with 216 of 2023. Full stop. Where the petitioner, who is the husband, had instituted FC 212
Lordship, page 19,
oblique
paragraph
21
6.
at before the learned family court Guwahati
My lord.
for restitution of conjugal rights. Full stop. In the state petition, And during the, with regard to the same proceeding, the respondent wife had filed a transfer petition being transfer petition C 15 of 2022 in this court for transfer of the proceeding from Guwahati to Lakhimpur, in which the present petitioner had appeared and contested. Full stop. In the meantime, the respondent had also filed his case 78 of 2021 under section 125 CRP for maintenance at Lakhimpur. Full stop. Whereon, reporting the learned counsel for the petitioner has however submitted that in the transfer petition, this court had directed the parties to sit for mediation, and in the same mediation, the parties had come to an agreement that the marriage between the parties would be mutually dissolved with a permanent element of rupees 5 lakh.
5 lakh.
It is submitted that the entire amount of rupees 5 lakh was paid, whereafter a joint petition under section 13B has been filed on 17/2/2023
Lordship,
before the learned
family court, family.
Guwahati, which has been registered as FC Civil 216 of 2023. Full stop.
The dates on which the proceedings continued are 17/2 to
The basic grievance is with regard to the insistence of the learned family court to
13.
defer the proceeding by 6 months as required under section 13B of the Hindu Marriage Act 1955. Reporting the learned counsel has submitted that the period prescribed by the statute is only to ensure that the consent given is free and a considered consent, and the same persists and is consistent for the period of 6 months. Full stop. However, the same provision of the statute has been interpreted by the Honorable Supreme Court in the case of Amardeep Singh versus Arvind Kaur,
2017,
reported
8
in 2017,
8
8 746, which is also referred to in a subsequent judgment dated 11 December 2021 of the Honorable Supreme Court in civil appeal number 7650 of 2021, within bracket Amit Kumar versus Suman Beniwal. Full stop. It is submitted that because of the delay, the petitioner is required to pay an additional amount of rupees
4,000 per day.
4,000 per
Date.
date to facilitate appearance of the respondent at Guwahati, which is wholly unnecessary, as for all purposes, the parties have consented to a dissolution of the marriage, and such report of the mediation dated 7/11/2022 is also reflected in the order dated 14/12/2020 of this court, by which the transfer petition was closed to withdrawal.
Further,
Though this court is of the opinion that a case for passing appropriate orders have been made out, it would, in the fitness of things, such order is required to be passed in presence of both the parties. Full stop. Para. Triphonic Tenancy Council submits that the next date fixed before the learned family court Assam, family court
Kamrup,
Guwahati, is on
17th of August.
17th of August. Full stop. He submits that the petitioner would be able to serve a copy of the petition along with information about the next date to the respondent, so as to facilitate her to appear before this court. Para. Liberty for serving notice of this case upon the respondent on the next day before the family court is granted. Let the next date, let this case be listed next on
22nd
22nd of
August.
or you can have it on 21st also.
21st, I'm not there.
Okay.
22nd.
On 22nd of August 2023. The fact of serving notice to the respondent may be brought on record by way of an affidavit, so as to enable this court to pass appropriate orders on the next date.
Would my lord be pleased to have a look at page 8?
Yes.
4,000 per date interim, because again the next date comes. Some
Next
observation.
date you have to pay only. 17th you have to pay.
17 again I have to pay, my lord. That is the only crux. I have paid everything.
Understood.
That observation would send a correct light towards them.
Let us see. No, right now we're not saying.
Then again, my lord,
This is the last time we'll be paying. Hopefully.
interim prayer to be considered on 22nd.
Not
That much.
interim. You're going to continue.
I understand. We do not know what turns up.
Yes.
We do
At
not.
that time we'll consider.
Obliged. For motion.
No, for
For
motion.
motion. Obliged.
Not for admission. Right? For motion.
Motion.
Please go. File the affidavit on Monday.
Yes.
Mr. Bonik, take a certified copy of this order. You'll get it today itself or tomorrow by
Your
Yes.
Lordship, may this matter be adjourned for the day my senior Mr. T. Islam is hospitalized.
Okay, which matter?
Item number 30.
Item number 13?
Yeah.
Oh. What does that represent?
His keratin has come up.
29. Okay, but we'll have it some other.
Lordship, moreover, this petition already admitted by order dated 14/6.
Is it?
Lordship. And thereafter, LCR was called for.
This 14th, you're correct. Admit it.
Lordship.
A prayer for adjournment. Madam, your name?
Kedas.
Kedas. MS Kedas, Learned Counsel, submit that her senior treatise from is unwell and therefore pays for an adjournment. Presume here to Learned Counsel for the petitioner. However, submit that though this matter has been listed under the admission column, on 14/6/2023, the petition has already been admitted. You're for all the respondents, madam,
Oh, yeah, respondent number 5.
5. Other respondents served or not?
Appear, Lordship, served,
Served.
Lordship.
No, madam, you're for all the respondents. One
All
to eight,
the
one to eight,
respondents.
not 5, 1 to 8, all the respondents.
Yeah, 1 to 8.
All the 8 respondents are there.
Yeah.
Therefore, um, that's the- admitted, and the respondent have already entered a pair. Full stop, madam. Please, after 2 weeks,
Lordship. Lordship, earlier interim order may be continued.
is there any interim order?
Lordship, order was there, earlier interim order.
Last 2 days, you did not make any mention of
Lordship.
extending the interim order. The interim order, what is the nature of the interim order?
It is provided that till the returnable that the further proceeding of title execution number such and such pending in the court of Planet Munsibna Marwan Dorong shall remain state. It was order on
We have
21.
seen the order.
Lordship.
Suit is yours.
No, Lord.
Their suit. Thereafter, what has happened? There is no extension of the interim order on 2 occasions.
Lordship might have been that.
There are interim order passed earlier, however, stands extended till the next date of it.
Probably.
2 weeks, madam.
May it please the Lord.
Yes.
This is an appeal, my lord. It was in fact, my lord, application under 13B was filed, my lord, where they had agreed, my lord, that no maintenance or alimony would be required, my lord. My lord, in fact, the wife was living an adulterous life, my lord. In fact, that has been admitted in the cross-examination of the DB, on the basis of which, my lord, this application was filed. Now, what has happened, my lord, while, my lord, in the even in the joint evidence file, my lord, they said that they would not require any evidence. Sorry, my lord, alimony, my lord. But at page 41, my lord, while, my lord, decreeing the, my lord, petition, my lord, suit, my lord, an amount of 10 lakhs was paid towards permanent alimony. That is under challenge.
This was on mutual consent.
Mutual consent. Your lordship will find the, my lord, page 22, my lord, annexure B, and your lordship will see page 25, my lord, paragraph 8.
Yes.
She is living with someone else, my lord, as husband and wife. My lord, paragraph 8, my lord, that both the parties have mutually decided and agreed they will not raise any demand for any interim maintenance or permanent alimony from each other for the divorce in between them. Then if a lordship finally comes to 34 again, my lord.
Which page?
Page 34, my lord, is the joint evidence which was filed, my lord, paragraph 9 and 12, my lord. Now, what, my lord, initially, my lord, the wife filed a petition under the Domestic Violence Act, my lord. In the cross-examination, my lord, she admitted that she was living in adultery, my lord, and in fact, not one, my lord, but many. So thereafter, this joint petition was filed. 9 in paragraph 12.
This is the evidence.
Evidence, my lord, joint evidence filed by both the parties.
Joint evidence.
It starts at page 32, my lord. And
And which paragraph 12 also?
paragraph 12, my lord.
12.
That we have both mutually decided that we will not raise any demand for any interim maintenance or permanent relief from each other.
Okay.
Now, lordship, But at page 41, my lord.
Yes.
However, considering the
We already done it wrong. Where is your IA?
my lord, it was filed in a hurry, my lord. I'll have to file it again, my lord.
I
I understand.
admit this,
Lordship.
or you defer admission to the same.
No, Lordship may admit it in the meantime. I'll file my.
We already done it counsel for the who have heard this appeal under section 28 of the Hindu Marriage Act 1955 being aggrieved by a part of the judgment decree dated 3/6/2023 passed by the learned district judge Chief Sagar entitled to M 84 of 2022. Para the brief submission of the learned counsel for the appellant is there. An application under section 13B of the Act of 1955 was filed by the petition and the respondent for dissolution of their marriage on mutual consent. In the state petition, comma, a specific pleading has been made that neither of the parties would demand for any interim maintenance or permanent alimony. And in this regard, comma, paragraph 8 of the petition has been referred to. 3D has also referred to the examination in chief in the joint evidence filed on affidavit. More specific, those made in paragraph numbers 9 and 12, wherein a similar declaration regarding no claim for maintenance has been made. However, comma, by the aforesaid judgment and declared 3/6/2023, while the marriage has been dissolved, comma, a permanent element of ₹10 tax is directed to be paid by the petition suitor. Admit all for the record. Step for service of notice upon the sole responsibility be taken by usual process as well as by registered post office. Step within 2 days. List of the 6 weeks along with report on LCR as well as on service. Parties are at the petitioner is at liberty to file appropriate IA for necessary direction.
May please, your lordship. Lordship, MSc
Sir,
appeal, my
Konika,
lord.
you appear for Tokyo.
Lordship.
There is a matter where notices have been served,
Lordship, we have already received the notice. ma'am.
some dismissed for default.
Yes, ma'am.
We wanted to pass final orders, but your notices are served in some fluid automobile. Is it your office?
This is not the office actually, ma'am.
Cannot be.
This is not the office.
But there was a still from fluid automobile, if you remember.
Some Lohit called Lohit.
Lohit or Louis automobile. Louis.
Lohit. This is not the office of the company, ma'am.
Is it situated in the same premise?
In fact, my lord, the office is at Kolkata, my lord.
You don't have office at Guwahati.
No, my lord.
How was it served? And this was the same address in the tribunal. Because this matter was taken up last Friday, I think.
Yes, Lordship.
Remember,
The
remember.
council talked to me, Lordship, that day. I have received the notice, my lord. I will appear, my lord.
Yes, what is this?
Lordship, here, my lord, the claim application was filed under section 166, my lord. The Lordship, my lord, deceased, my lord, fell down from a moving motorcycle. And there was no PS case registered in respect of the accident, my lord. Though, my lord, the case was filed under section 166, my lord, compensation was allowed, my lord. That is my ground, my lord, and moreover, my lord, regarding quantum also,
Is registration of a police case enough or not?
it's not required, my lord, because since the petition is filed under section 166, my lord, the rash and negligence is required to be proved. In fact, there is
That was
no,
not proved.
that was not proved, my lord, because the admitted fact is that he simply fell down from the
No,
motorcycle,
he
my
fell
lord.
down, but was it because of some rash and negligent act? He fell down.
He fell down,
The
he
reason
sustained
that
injury in the head, my lord.
No, the reason of falling down may be rash and negligent driving. He was a pillion rider.
Yes, my lord. Yes,
How much is the
my lord. The lordship-
injury case?
Death case, my lord,
That case.
17 lakhs, my lord. We'll deposit 50%, my lord.
That case. What was it doing?
He was a retired pensioner, my lord. He was a retired government service holder.
What was the
62.
you were that is one ground. The other ground,
Lordship, my ground is that, my lord,
the
the
other one.
other one, my lord, the pension, my lord. The pension was taken as a monthly income, my lord. So my understanding is that pension is not a monthly income, rather it's a privilege for rendering service to an organization, my lord. So it cannot be based for compensation of the under MVA, my lord, because the monthly income,
can be curtailed or stopped.
no, that is the reason, my lord. Since it is not, it cannot be curtailed, my lord. So it cannot be there at the same time.
It is pension. It is part of the. It's an acknowledgement of the services rendered.
Lordship,
You
Lordship,
cannot say that it's something gratis or something in grace they are being paid pension. It's a matter of right.
Lordship. But my point is that, my lord, I may be, my lord, the point is that, my lord, if the pension cannot be curtailed or it cannot be deducted,
He had worked where? Who was the employer?
Lordship.
Private employer.
No, my lord, government employee, my lord.
See, even family pension concept is there.
Family
These are all
pension,
statutory
they are
requirements.
receiving family pension as well, my lord.
There is the statutory requirement.
Lordship.
Don't term this to be something a grace, act of grace or something. Those days are gone long time back. These are matters of right, absolute right. Okay, we admit this. Third critically, Senate Council for the appellant who has preferred this appeal under section 173 of the Motor Vehicles Act being aggrieved by a judgment and award dated 28/2/2023 passed by the learned M.E.C.T. Nalbadi in MSC case number 48 of 2016 by the impugned judgment, an award of rupees 17,67,752 has been granted to the claimant who is the wife of the deceased. Also, Sarah. Sri Kolita has submitted that rash and negligent driving has not been proved in this case, and the assessment of income is not proper. Admit, call for the record. Let them for service of notice upon the respondents be taken by usual process as well as by registered post. Step within 3 days. List of the 6 weeks along with report on LCR as well as service. I Third, Sriti Kolitalan and counsel for the applicant appellant who by means of this application has paid for stay of the judgment and ordered it is the appeal filed, the appeal preferred against the state judgment has been admitted today, that is to in the connected MSC appeal number 316 of 2023. The Kolita, the learned counsel for the applicant appellant submit that there are good grounds of appeal which is likely to succeed. Considering that the award has been passed by the learned MS commanded to in a death case, this court is inclined to pass a conditional order of the court. It is accordingly directed that pending disposal of the appeal from the impugned judgment and ordered it awarded it to the past judgment shall remain suspended subject to condition of deposit of 50% of the awarded amount in the registry of this court within a period of 2 months from where I stand this.
Much.
May I please, Lordship? Lordship, this is appeal against judgment and award passed by MSc Tribunal, Lordship, Sonitpur. Lordship, my claim was 16 lakhs, but the learned tribunal has passed only total 92 lakhs, Lordship, 92,000, Lordship.
You're against the adequacy of the amount.
Yes, Lordship.
You want enhancement.
Yes, Lordship.
Third, MSB Talukdar, Senate Council
Be
for,
followed.
for the appellant who has preferred this appeal under section 173 of the Motor Vehicles Act being aggrieved by the adequacy of the award passed by the learned MACT Sonitpur in MSc within bracket I case number 79 of 2019. It is submitted that while the claim was for rupees
For rupees 16 lakhs, 58,000,
was for amount of more than rupees 16 lakh, comma,
58,000.
more than an award of rupees 92,000,077 has been granted. The learned counsel submits that the tribunal has erred in assessing the income and also in other factors. Admit there are also the records as step registered proceedings 2 days 6 steps registered post as well as usual post.
Much of that. Report on service. Yes,
This is application filed under ground that there is a violation of policy condition. And in spite of that, remedy of pain recovery was not given to them. As per FIR and charge sheet, the vehicle was carrying 11 persons, whereas it was authorized to carry only 3%. As per FIR and charge sheet.
in one case, you are saying that option of pay and recovery has not been given. In another case, you are aggrieved by a pay and recovery.
Yes, Lord. It's,
Why?
in fact, the issue is unfortunately, it
Why
is
are
not
you-
yet
why
settled.
are you not consistent?
Lordship,
in your
what has happened is,
We have also a case, if we have to take a call, it has come up before us on 2 occasions. Unfortunately, not taken.
Unfortunately, even in our court, lordship, there is a decision which is high courts or lower courts do not have the order power to order paid. In that case, what will happen is for absolute violation of policy conditions, it will be the owner who will have to, but the claimant cannot be made to run after the owner. It's a beneficial piece of license for him.
That is
If
it.
we have any contest on such, it's with the owner. He cannot be made to run from failure to occur. So I am for lordship keeping the beneficial legislation in mind.
Now, how do you reconcile? There is one appeal which the grievance is for against the observation of pay and recoup.
If my personal take in this is lordship, beneficial legislation, and either it's a case of what will happen is when it's a case of no policy,
Okay.
the owner would be liable.
Yes. No, that is the objective.
But
That
violation is
that is your entire objective. Your
yes.
submission is absolutely correct that you cannot make a person who is already
Run from
distressed
that was
to
the
run
problem.
for the money. Okay. Hartford Argus Millennium Council, who has preferred this appeal under section 173 of the Motor Vehicles Act, being aggrieved by a judgment and award dated 29/5/2023, passed by the learned M. E. Kitty Kamrup M. in MEC case number 726 of 2016. It is submitted that there was violation of the policy condition, and by overlooking those aspects, the award has been passed, and there is not even the condition attached regarding allowing payment and recovery. Para admit, para call for the record. You take steps forced by usual and
Yes, sir.
registered post dating within 3 days. No, 6 weeks.
Lordship, may I be allowed to take dusty service? Will cut short that time, lordship, without registration.
No, you take, if you fail in that, will allow us.
First is
You have filed?
yes, sir, I have filed.
50%.
I have filed.
50%, 6 months, 6 weeks.
Obliged. I'll leave. Deeply amended.
Yes. Yes.
Wait, please, your lordship. Lordship, here, my lord, we are also challenging the quantum, my lord.
Quantum.
Lordship.
Why? What is that? How much?
Lordship, the quantum is, of course, less, my lord, 16 lakhs, my lord.
That case.
That case, my lord. That case.
What did he do? What was the
His
deceased
income was not proved, my lord.
What was the deceased doing?
His income was not proved,
Now, what was he doing
lordship.
as per the claim petition?
Lordship. Business of clothes, my lord.
Age?
Age 26. 26.
He prevailed upon your client. These are not
Lordship,
matters.
Lordship, I have another ground, my lord, which might be appreciated, my lord, because Lord, there is a statutory breach on the part of the deceased, my lord. That ground I have taken
What
because
breach?
that section 129 of the MB Act, my lord, because he was a pillion rider in a motorcycle, my lord, and it was found that he was not wearing helmet, my lord, and that has been the breach on the part of the.
Those will have other consequences, but not in an insurance matter.
Lordship,
You
my lord,
cannot drag each and every matter to an insurance. This the entire law of tort has been codified into an act. Otherwise, it is not tortious liability. the enactment has made a tribunal, you go to a tribunal, it's only been thought to be made in a systematic manner. You cannot do away with your liability. Hard. Same, huh? Equal it. Appeal 173. Where are the- Yes, यहाँ पे दिख- Appeal दिया है 16,37,000. The appeal has been filed, being agreed by the Contempt and it has also been submitted that there were violations of some statutory conditions. But it- You take steps by both ways.
Lordship.
Put it to the it is the- if 6 months, 6 weeks. 6 weeks. With report. And she is him. Equally. 50%.
Much.
Yes, next.
My lord, first of all, I pray that my lord, the appellant could not submit WS at the time of filing the appeal matter because it was not available. I may be allowed to
What was not available
WS,
in the,
a copy of WS is required. My lord. So maybe about 10 days time I will submit my.
your arrest without a WS, how was it accepted by the court?
Yes, my lord, that was,
Yes, now Senate counsel for the appellant submit that at the time of filing this appeal, the written statement was not readily available.
yes,
And to avoid the issue of limitation, it was filed without a written statement, which however has been obtained at a later stage. According to press, is granted a week time to have the state written statement as a part of the record. File it.
published. Maybe your lordship.
Yes.
This is a appeal preferred against the concurrent judgment of both the learned court below, my lord. My lord, what happened, my lord? The present appellant, present respondent, as plaintiff file title suit number 9 of 2013, my lord.
Just a You are the plaintiff.
I am the defendant, my lord.
Appellant is the defendant.
Yes, my lord.
Suit for
Suit for declaration of right title interest and ejectment, my lord. And for recovery of area rent, my lord. My lord, the respondent as plaintiff file title sheet number 9 of 13, my lord, before the learned court of civil judge.
where? Amru.
Jorhat, my lord.
Okay. And
Jorhat, my lord. And the contention of the plaintiff was that, my lord, the Suitland originally belongs to their father, my lord, and they have inherited the property, my lord. And in paragraph number 5 of the plaintiff, they have specifically stated that plaintiff and pro forma defendant being the Brahmin
community were allowing the defendant to cultivate over the woodland, my lord, for which the plaintiff and other plaintiff after death of their father allowed the defendant to cultivate the woodland. So from the month of April 2003, my lord. So admittedly, yes, my lord. There are 5 of the plain, my lord. Page 23, my lord. So, and they stated that the defendant fails to pay the rent, my lord, as well as they made some act which make the impair the woodland, my lord, for which they filed a suit before the learned court below with a prayer for ejectment,
Yes.
recovery of payment and declarations. The defendant
How much
appeared,
was the plot of land?
my lord,
How much was the?
my lord, area of land 10 bigha, 4 kotha, 15 lesa of the of various that, patta number 33, my lord, of Gohin Gaon, Mouja, Chimuluguri district, Jorhat, my lord.
Okay.
Yes. Yes, my lord. The defendant appeared, my lord, and in paragraph 3 and 6 of their
How many of you are there?
my lord, only defendant 1 and 2 file the
You are
request,
representing how many?
my lord.
You are representing how many defendants?
My lord, all the, my lord, the
The present appellants are all the
present
defendants?
appellant are defendant, my
All
lord.
the defendants.
There are 8 numbers of appellant, my lord, and
I have all the defendants. Staff appellants.
not all, my, there is also performer defendant, my lord.
Okay, doesn't matter. Okay, then what is
Yes,
it?
my lord.
You
No.
contested.
I filed the written statement, but there is no evidence, my lord, from the side of the defendant because they did not appear for cross-examination and the evidence was expunged, my lord. In paragraph 6 of the of our written statement, he admitted, yes, my lord, we are the cultivator or we are tenant under the plaintiff, my lord, since the time of their forefather, my lord. Yes. Yes,
Then-
yes,
But you did not reduce evidence.
yes, ma'am. But the learned court below, without considering the provision of Assam Temporary Settled Tenancy Act,
Did you file an application under 71 Act?
my lord, admittedly, they have the plaintiff has stated that I am a tenant under the,
No, did you file an application under 71 Act does not come into operation on its own unless you file an application.
my
There's a
lord,
prescribed format, I think form 5.
yes, my lord, but they have stated, we also admitted, my lord.
You are
The-
tenant, but did you approach the under the?
I did not approach the
Then how
deputy
will it
commissioner, my lord.
automatically come in? How will it automatically
My
come
lord,
in?
as there is a
You have
good
to be
relation,
liable.
as there is a good relation, we have stated in written statement, but it does not prove because there is no evidence on that part, my lord.
No,
We have stated,
Mr.
my
Das, you may be correct. You may be a tenant prior, but unless you invoke the provisions of the 71 Act,
yes, my lord.
how it doesn't automatically come in the way. And this is not a civil proceeding under the civil code. It is has got a different connotation. You approach the deputy commissioner, the office of the deputy commissioner. He'll pass appropriate orders.
My lord, actually, my lord, according to 71 Act, my tenancy act, my lord, they have admitted, my lord, that I am holding the possession of the land, my lord, as cultivator for a period of more than 3 years, my lord. So
Mr. Das,
by,
have you filed any proceeding, initiated any proceeding under 71 Act?
I have not filed any proceeding, my lord, for claiming right, my lord.
Automatically,
Section 23, my lord.
automatically will not come. I think form 5 under 23. What was that form?
I may apply for the ownership right under 23, my lord, section.
You may apply, you have not done that.
I have not applied for the ownership right, my lord.
Yes, form 5 under rule 9. Under the rules of 72. You have to file appropriate application. Format even is given.
Yes, my lord.
The 23 is with regard to acquisition of ownership rights.
Yes.
And intermediary rights by the tenant.
Yes.
And this 71 Act,
My lord, may I submit, my lord?
Yes.
My lord, it is not a dispute for acquisition of ownership right under the landlord, my lord.
yes,
My lord, it is a dispute between the landlord and tenant, my lord, regarding the tenancy, my lord.
correct.
So we did not apply for the in form number 5 of rule 9, my lord. So rule 9, my lord, related to the section 23, my lord, for acquisition of ownership right by the tenant, my lord. I never claim any ownership right, my lord. They have stated that I failed to pay the rent and I make impair of the disputed suit land, my lord. That is why they filed the suit. But according to them, if the suit is required to be decreed, my lord, they have to come under section 54 of the Tenancy Act, my lord. They have give notice, my lord, for payment of the rent, my lord. They have issued a notice, my lord, for giving
54 of which act?
of this Tenancy Act 71, my lord. Yeah. They have issued a notice, my lord. But that notice does not in accordance with the provision of the Act, my lord, section 54 of the Act, my lord.
See, to get yourself ejected, no tenant shall be ejected from his holding except in execution of an ejectment decree passed by a competent civil court.
Yes, my lord.
They have approached the civil court for ejectment.
My lord, that is, my lord, prior to that, my lord,
Yes.
so far my knowledge is concerned, my lord, so they have first complied the provision 51, my lord. Any tenant not being an occupancy tenant shall 51 2, my lord.
Yes.
Shall not be ejected from the land of his tenancy except in execution of a decree for ejectment
Yes.
passed on anyone or more of the following grounds,
Yes.
namely, my lord, kindly see my lord, that he has failed to pay the arrear of the rent, my lord. On that done, he may file the suit, my lord. Then your honor may kindly come to the section 54, my lord.
Yes.
Procedure for ejectment, my lord. No tenant shall be ejected from the holding except in execution of an ejectment decree passed by a competent civil court and the relevant provision of the civil procedure 1908 shall apply to such proceeding. My lord, kindly see the provision 4, my lord, subsection 4, my lord. No suit for ejectment on the ground mentioned in section 51 to subsection C, my lord, that the rent, my lord, shall be entertained unless first a decree for rent has been obtained. So they have obtained a decree, my lord. Then they have filed a suit for ejectment, my lord. If I fail to pay and that decree is if the
This decree is not for arrears of rent. This decree is not for arrears of rent.
arrear rent, my lord.
Then
That's it for arrear rent. First decree they have to obtain and they have given the honorable learned court below required to give a time, my lord, to pay the rent, my lord. The section 54 is very much clear, my lord, to that effect, my lord.
What are
If
your
I,
sub-
if
what are
I,
your- what are your substantial questions?
yes, my lord. The first part of the memo, whether both the learned court below have committed grave error of law and fact by declaring the suit of the respondent plaintiff, where notice as required under section 54(2) of Assam Temporary Settlement Tenancy Act 1971 was never served upon the defendant appellant, my lord, prior to filing of the suit, my lord. Next, my lord, whether both the learned court below illegally and arbitrarily perversely passed the impugned judgment and decree for ejectment of the appellant defendant and for recovery of the area rent of the share of
Let
works
us
of
see the
the,
issues. Let us see the issues.
my lord,
Let us see the issues framed.
issues your frame, my lord.
Where?
Yes, my lord.
There is no issue regarding.
My lord,
There is
22,
no
my
issue
lord.
regarding notice. How can you raise it in the second appeal now?
My lord.
There is no such issue.
Yes, ma'am. Page number 25, my lord.
The trial court has framed issues on 17/1/2014.
Yes.
5 issues were framed.
Yes, ma'am.
There is no issue of the contention which you are now raising regarding
My
54.
lord, it is completely a question of law, my lord.
You have to raise it. You have passed by an appellate stage. We are in second appeal.
My lord, yes, my lord, it is a question of law. Question of
Question
law
of
can
law.
be
It has
raised
to be a
at any
substantial
stage, my
question
lord.
of law pertaining to the case. Substantial question of law does not mean a big question of law. It has to be substantial to the issue at hand.
Issue, my lord, my lord, learned court below frame the issue, my lord. But declaration of the right title interest, all this thing, my lord.
There is nothing you show us anywhere in the WS that you have taken this
My
point.
lord, our WS is not the matter in this case because I have not substantiated my WS, my lord.
No,
because-
even if you have taken in the WS, see, you are a defendant.
Yes,
You are just required to contest the suit. For the plaintiff, if they do not produce any evidence, the case goes. But defendant's position is a bit different. You have contested the suit. You may not produce evidence. That by that, your suit cannot be decreed against you automatically. You still have the right to cross-examine, which you have done probably.
My lord, they have to, it is their case, my lord.
Their case, they have proved.
They have to prove, my
They
lord.
have proved.
Yes, ma'am.
Let us see your WS. Where is your point?
Yes, my lord. Our WS is start from page number 28, my lord.
28.
In para number 3 and 6, my lord. We have admitted, my lord, in our WS, my lord.
3 and 6.
That, yes, my lord, I am the tenant under them, my lord. Para number 6 at page 30, my lord. That the, as part of the sentence of para number 5 of the plain, the fact of the plaintiff and the performer defendant being the Brahmin community away from the cultivating the land.
Nothing about any notice.
We have
You
admitted that
forget
case, my
about
lord.
these statutory provisions. You should have said, I have not been given notice.
But learned could below.
Difficult issue. 52, 54, to raising for the first time, that in a second appeal.
Yes. My lord, the learned could below required to frame the issue, my lord, whether the learned could below can pass a degree without following the provision of section 54 of Tenancy Act, my lord.
Our issues framed. Issue is framed after hearing both the parties contention. Wherever there is a dispute, the issue will be framed there. You have not even said that notice has not been issued to us.
My lord, I may be giving some time, my lord, to satisfy your
We may
lordship,
not,
my lord.
you may not quote the section or even mention the section, but you have to state in substance that notice was never served upon us.
Yes, ma'am.
If that factual part you have pleaded, then you could have said, yes, law also provides. I have not quoted the section, but I have made substantial averments in my WS. You have not made the averment. Madam, what do you say?
Madam, I may be giving some time, my lord, to satisfy your lord.
My lord, my submission is that, my lord, both the courts very rightly passed the impugn and your lordship may not interfere with that.
No, he's trying to raise a substantial question that under the 71 Act,
Section
he may not go to the aspect of seeking ownership right. But even to evict a tenant, you need to first issue a notice, which you have not pleaded. It is a different matter that in the WS he has not said anything about the notice. But he is now trying to raise that before you evict the tenant who is cultivating, a 50 notice under 51 is marked. And it is only by a valid decree of a civil court that you can eject. You haven't obtained a decree. But prior to the decree, there is a necessity of issuing a notice. You have not done so. We grant some time. You look into some aspect in the WS, there may be some statement. Third,
WS is silent.
third CPP does not account for the appellant, whereas MSP Bhattacharya and counsel is present for the response number 1. Where on the prayer of Sridhar, Sridhar, however, makes a prayer for adjournment. This after 1 week.
2 weeks, my lord. I'll-
The Lordship.
Yes.
This was an appeal arising from title appeal number 41, 2011, passed by the Munsif number 1 Borpeka. Your Honor, the petitioner number 1 is already died, and there is an agreement between the petitioners and the respondents. So the rest of the petitioners would like to withdraw the case.
What is the case?
Yes, Your Lordship.
What is your name, madam?
Masjid Hayat.
You're on record.
Yes, Your Lordship.
You have got proper instructions.
Yes, Your Lordship, there is an agreement. There is an agreement between the petitioners and the respondent,
Okay.
and the death certificate of the
I am
petitioner.
for the
number 1.
respondents.
Are you aware of the agreement?
Not agreement, I am instructed that they will withdraw the case because some compromise has been made.
Yes, Your Lordship.
Okay, then it is okay.
Oh, sorry.
MS as yet hired Senate counsel for the appellant, whereas we and Senate counsel is present for all the respondents. Before going into the merits of the dispute from MS hired the Senate counsel for the appellant has submitted that while the appellant number 1 has passed away, there is an agreement of compromise between the rest of the appellant along with the contesting respondent. But your agreement needs to be in a degree of compromise.
Your Lordship, they have made
This is
an
not a
agreement.
petition that you withdraw. You may be in difficulty tomorrow. Unless this fortifies into it takes the form of a degree of compromise. Your advice may not be correct. We don't mind dismissing on withdrawal, but may have difficulties tomorrow.
Can it
You
be
will
by
proceed.
after a week? I can also my thought option from this time.
You take instruction. You have the CPC.
Yes, no, with me, I don't have some.
You know
Right.
what is a compromise decree? How is it affected?
Your Lordship, let the matter be listened after 1 week so that I can also take
Take instruction.
steps.
We can, you are willing, we can send the matter for remand and pass an decree on compromise. So you are plenty forward.
Yes, I'm
The
for the
defendant,
Huh?
I am for the play.
plenty,
See?
we are for the dependent.
There is a decree against you.
Yes, Your Lordship.
If the plaintiff suit was dismissed, the matter would have been different. Now, just tell it. Last. So on the prayer, on a joint prayer of the learned counsel for the parties, the matter is adjourned by a week or 10 days. By 10 days to enable the parties to seek necessary instructions regarding the next course of action. Yes, next.
Obliged.
Please, my lord. My lords, here an affidavit was to be filed on behalf of respondent number 5 regarding the expiry of respondent number 5 has expired. Respondent number 3 had where to file an affidavit in
Who is
that regard.
3?
They are the insurance company, my lord.
Madam, you have for 3.
Yes.
Who is 5 then?
5 was the driver of one of the vehicles, my lord, involved in the accident.
Oh, you are given time to file affidavit.
No, why will we file like this?
I don't know why. As per office note dated respondent number 5 expired, therefore Ms. Mazumdar has sought for some time to file necessary.
No, Lordship, because they are the appellant. How can we file? And it is on their notice only it has come. I don't know. I didn't check the office note.
You have to check the file.
Yes.
Check the order also, not only the office.
Then it has to go to the appropriate bench, Lordship, because affidavit.
If he has filed, either you strike off or you substitute.
Lordship,
Is the driver?
it is,
You're on quantum.
yeah, we are on quantum, my lord.
Memorandum.
There is no allegation of violation of any.
My lord, we only want enhancement of the amount.
Then he can
And-
strike off it.
Yes, it can be. They already got 63,34,756.
He will respect you. Strike off. But the LD, that is counsel for the appellant, whereas MS on the last occasion who had appeared, T. Mazumdar, maybe a wrong instruction had gone. Where MS RD Mazumdar, current counsel has appeared for respondent number 3 in full stop. Though this court on the last occasion, that is court 220 had made an observation that an affidavit not made on the law of the last occasion, this court had granted time to the learned counsel for the insurance company to file affidavit after recording that the respondent number 5 has expired. Is submitted that no such affidavit is required. So this court has also been apprised that since the particular since this present appeal is for announcement and the respondent number 5 was the driver
Of one of the vehicles. There were
of
two
one of
vehicles.
the vehicles, his presence may not be necessary. According to according to the name of the respondent number 5 is struck off from the area of party. Record them now. Since healthcare
No, it is a delay petition. Lord.
Huh?
Delay
No.
petition. No, yeah.
main appeal.
Oh, how much maybe DNA?
Respondent number 6 also, your lordship has not entered appearance. We have, as per the office note, 1, 2, and 4 have been served, my lord.
We need to admit this. Notice was this.
That's why I thought it is a delay. It can be admitted. Lord.
We admit this.
And I said that.
It further appeared that the appeal is yet to be admitted. However, pursuant to the order dated 6/10/2016, the LCR has been received. Full stop. That's admit the appeal. MS RD Mazumdar, current counsel has already entered appeal
Respondent three.
for the respondent number
Three.
three. What about the others?
My lord, 1, 2, and 4, my lord, as per the office note, they have been served to registered post. 6 also we have issued notice, my lord, but nobody has entered appearance.
Comparative knowledge. Notice quick.
Appeal of which year?
2016, my lord.
It is submitted. RD is submitted. That steps were earlier taken for the rest of the respondents who have chosen not to appear. And this court has already struck off the name of respondent number 5. Since the appeal is for enhancement, which the contesting is present, no press notice are required to be issued at this stage. This for hearing.
Lordship, notice may be necessary on respondent number 6, my lord, because that is also another insurance company.
For 6.
Lordship.
I'll inform them, Lordship. United India Insurance.
No press notice may be required for the respondent numbers 1,
2, and 4, my lord.
and 4. Full stop. As far as respondent number 6 is concerned, that step be taken for service of notice by registered post office. Steps within 3 days. You can also inform informally to the internet account. List after 6 weeks along with service report upon the respondent.
Will it be possible, my lord, to fix the date?
No, come up with the service report. We'll fix the date. Whereafter a date of hearing.
Lord.
Most obliged. Whereafter this court will consider this court hearing, fixing a hearing. Yes.
Lordship, the respondent here has already appeared. So far, the office note 24/7 LCR also received, Lord.
You are for appellant,
Lord.
for an appellant.
Lord.
Just like, yeah, you for
Respondent number 3.
others.
Other already they have ex party for the trial.
It has been admitted or not?
Lordship, 30/11/26 for the mechanic.
30, 11, 20,
16.
20. Who is one?
Lordship, driver and owner one and
One is yet to be served.
they have not also contested in the case here.
Yep. Who has received back? Who is complete? one, I think you have to take first step. Then, or if you have the instruction, you can try to.
Lord, can strike up because it is only in respect of enhancement.
Yes, like you are the contesting
It is the contact.
or the alcohol, then it conflict for the appellant. Also, hard to is a second. Then it conflict for the respondent. Number three, insurance conflict. Apparent. This appeal has been admitted on 30/11/2016 and records were called for, which have been
Receive,
recorded,
receive 24/7 office.
which have, that have been received. The Mohan Lieutenant Council has submitted that as per office note dated 24/4/2019, ID card of the respondent number 2 has received back. However, there is no response from the respondent number 1. The fee, however, submits that since this appeal is for enhancement and the contesting insurance company is present, this appeal, absence of the respondent number 1 would not make any difference. Get the difference. List for according to list for hearing in its turn.
Lordship, my lord, similarly situated, my lord, the continuation of delay, this honorable court dismissed, my lord. Three numbers of cases, my lord, and my lord, similar case already judgment is reserved.
Those cases are for substitution of legal hair, my lord. And lordship was pleased to dismiss those petitions. My lord, here is no, my lord, substitution petition, my lord. Only delay in filing, my lord. And my lord, by the last order,
The delay.
my lord, I was directed to
204 days, my lord.
prepare a table, my lord.
204 days delay, my lord.
204.
And my lord, this there is no ground for my lord filing the continuation of delay, my lord. Kindly see similarly situated three cases of this honorable court.
Those are not similarly situated, my lord. Those are my.
204 is not that much of delay.
And my lord, in 26 number of cases, my lord, already delay has been condoned, my lord.
204 days, and
And my lord, those cases are, my lord, already, but final hearing took place, my lord, and it is, my lord, reserved for judgment, my lord, CAV. I have prepared a list
I'm
also, my lord.
waiting for judgment, my lord.
This is LA appeal over.
My lord, I'm waiting for judgment.
Then we do one thing, we postpone consideration of this.
And my lord,
if the judgment is in your favor, then we condemn the delay.
My lord, my lord.
If the judgment is
lordship
against
may
you,
condemn the delay, my lord, and my lord,
Open court judgment is declared, my lord, but judgment is not passed.
judgment is what? It's been declared.
Declared in open court dictation, my lord, judgment is not delivered.
No, that is okay. What was the delivery? What was the judgment?
Judgment, my lord,
no, my lord, it was not dictated, my lord, in open court. My lord. To my knowledge, my lord, I was present there, my lord. So,
so my lord, waiting, my lord.
that's,
Was it dictated?
my lord, not in open court, my lord, CAV, my lord, as per my lord,
Then why are you making this?
CAV,
No, my lord.
it
I
is
am-
shown,
I
my
am
lord,
in
in
the
the
court, my lord.
website, my lord. All the
You
cases
were
are,
present.
Yes.
Your friend was not present.
Present, also present.
well, CAV, my lord, it's what CAV
my
was
lord,
there, my lord, in the website,
I'm
my lord.
waiting for judgment, my lord. Whatever order is judgment, my lord, I agree. My
Now what
Well,
was
my lord,
dictated?
it may go against me, my lord. My lord,
Suppose I
I
am, my
admit
lord,
that,
offend,
my
my
lord.
lord, that my
There
lord
is
is
probability
my
of
lord.
going against me, my lord. I admit that, my lord, but it was not, my lord, dictated in the.
Then what is inevitable? Let us complete, finish it, please.
My lord,
When
my
it
lord,
is
lordship may
dismissing.
condemn the delay, and my lord, here the main case,
I
my lord.
file objection.
If the other appeals are being dismissed, why?
No, not dismissed, my lord. My lord, I have prepared the list, my lord.
On the way of being dismissed.
My lord, already, my lord, this
My lord,
dismissal order already record, my lord, kindly. Only the my,
Okay, hard. Please, go submit and concept for the.
my lord, the order is there. Dismissal order.
No, we are not doing. we're just deferring this.
My lord.
What the dismissal?
Well, it is there, my lord, in the, my lord, in the
Yes,
other
yes,
case, my
we
lord,
have-
it is
we have-
there probably.
We have.
Yes, my lord, it is there, my lord. Lots of order, my lord. My lord,
Mr. Hussain, you have given a list of the cases where judgment is reserved. Let us wait for some time. Part 3G goes to Contempt counsel for the appellant applicant, whereas the Judge Hussain, Contempt counsel is present for the private response. It is submitted that similar matters where heard and judgment is reserved. List after a month to enable the learned counsel to apprise the outcome of the
Item number, my lord, 25 and my lord, 39 is same.
39.
25.
39 you are appearing to.
my lord. My lord, in 20, yes, my lord.
Okay.
All right.
Keep playing.
17 matter, condonation. Delay condonation.
Yes, Lordship, condoning on delay of 224 days, Lordship.
17 matter where delay condonation was issued on 22, right?
Lordship, in the previous order, Lordship, it was ordered to issue notice, the respondent number. So we have, accordingly, we have issue notice, Lordship.
17 matter, delays of 17 2076. Notices were issued in 18 itself. Why a fresh notice?
Lordship, fresh notice issued on 24/8/2022, Lordship.
As of year for one.
Yes, Lordship.
Others to taken steps or not?
Yes, Lordship, we have taken steps on 24/8/2022.
No, after 14/6. 14/6, 2023 office note says that you have not taken fresh steps. This is Minister to nine. You are required to take the earlier office note is dated 27/9/2022, which says that you have taken steps for respond numbers 1, 2, and 3. Madam has appeared for respond number 1. There is a subsequent court order of 30/9/2022, which has directed you to take fresh steps upon the respondent. So you are required to take fresh steps. This one has already appeared for 2 and 3. You are delaying the proceedings. What is your name?
PD Bhuyan, Lordship. My name is not reflected.
Okay, doesn't matter. Office note dated 14/6/2023 has reflected that though the respondent number 1 has appeared by filing wakalat comma, fresh steps upon respondent numbers 2 and 3 have not been taken. Fresh steps were directed to be taken by this court by the order dated 30/9/2020. MSRD Mazumdar has appeared for the respondent number 1. Para. PD Bhuya, you have said. Para. The PD Bhuya on counsel appearing for the applicant. Accordingly, place point is granted 3 days time to take fresh step upon the respond numbers 2 and 3 for service of notice by registered post AD as well as by usual process. List after 6 weeks along with service, along with report on service. Take first step, both ways, usual as a registered post.
Much already.
Exactly.
Lord, we are directed to take fresh steps. We
Yeah.
have taken through registered post. But the service through Dasti could not be done, my lord, because the client could not come. And
Here for
That's not 1 year.
and that's the upon whom
respondent number 2.
you extend the date.
Yes, my lord.
Was the date fixed?
Yes, date was
As discussed, learned concept for the petition applicant submit that justice service could not be, the step for justice service could not be taken. And he accordingly pays for another opportunity. Also, your BB Kakoti,
D. Borua.
your D. Borua. Earlier, Mr. Kakoti had appeared. Sri D. Borua, learned counsel, has appeared for respond number 1. Para. That first step be taken for justice service upon the respond numbers
2, my lord.
who is free? Free, who is free?
Well, in delay condonation petition, 2 is the party.
No, no, who is free?
He was one of the defendants in the main suit, my lord. And respondent number 2 was also added as a defendant along with me. He was Ram Jahan Sahani.
No, was he is not required to be the served justice.
No, my lord. My lord, I'm praising this application under section 5 here. The 2 respondents are mentioned only, page 2. Others, my lord, were disposed of the substitution petition.
But this court, why is it mentioned? Oh, yes, that first step be taken for service of notice upon the respond number 2 by justice service. Fixing the next date to be thirteenth of September. Full stop. The state justice service is, however, required to fit to the registry of this court and in the notice accompanying the justice, comma, the next date is to be reflected. Full stop. Prior to the next date, comma, the applicant is required to file an affidavit as a proof of such justice service. 13.
Yes, ma'am.
Lordship, one submission, Lordship. My item is 46 and stay is involved in that. Kindly, if it is taken up.
You will go serially. All matters are important.
It will go and stay. It's already arbitration proceeding is suspended.
All
Lordship.
matters are important. It's not for you, your matter is important. For other counsel, their matters are important. We are going serially. We cannot give preference. Yes,
Okay.
next. We should have made a mention in the morning. We could have called the other side. Yes, What
May it please your lordship, delay 75 days lordship.
75 days?
Yes, lordship.
Notice is issued. Yes, they
Lordship.
appeared.
Yes, Lordship.
Lordship, similar,
Respondent.
similar matters have been fixed for hearing on 17 lordship.
Hearing for what, delay condemnation?
No,
No,
lordship.
Lordship. Main
LA appeal,
17.
17th August.
Here delay is yet to be controlled.
Yes,
Yes,
lordship.
What do you say?
But I have no objection, Lordship.
How much is the delay?
75 days, lordship.
Here for the
Private respondent, Lord.
all the private respondents.
All day.
Madam, your name is not there. Airport authority.
Yes, lordship. I am on behalf of Mr. R. Dubey, lordship.
The Dubey's name is also not there.
Yes, lordship. We have newly engaged in this matter, lordship.
Have you filed your power? No. Without Wakalatama, how can you allow it? It's a organization. Ask your client to
Lordship,
execute
similar matter
power.
also receive appear in Dubai, Lordship.
Who
Of Dubai, R. Dubai.
cannot appear just by saying in the court that I'll appear. Where is the power? Is he a government advocate that is appearing for the government without a wakalatnama? You cannot appear like this, madam.
Lordship.
Get your power.
Lordship, kindly adjourn this matter, lordship, for that day, lordship. We'll file in next day, we'll file our Bakalatnama, lordship.
Your name?
AB Kasta, lordship.
A.B. Kashyap. MS A.B. Kashyap, Senate Council submits that she along with her colleague, certainly along with her senior R to be have been instructed to appear on behalf of the Airport Authority of India. However, there is no formal power filed in the court of Tara. Senate Council accordingly prays for an instructed 2 weeks time to file formal wakalatnama.
Obliged, lordship.
May it please the Lordship. Lord, as per office note dated 9/8/2023, Miller, AD card received with respect to respondent number 3513.
Here for whom?
I am for the petitioner.
You had a new set of counsel.
My Lord.
Okay, it was mentioned in the morning that we did not allow because we saw different set of counsel.
Because my Lord, the NOC was issued by Mr. Islam, my Lord.
Doesn't matter. You
My-
can appear. No,
My-
Yes, what is your
My Lord, AD card with respect to the respondent number 3513, 17, 21, and 27, and 28, my Lord, received back by the section, my Lord. However, my Lord, service report with respect to the, my Lord, usual process is not received.
other there are about 22, 20.
My Lord, SO1 appeared in 1, 2,
Yes, we have
4,
seen that.
my Lord.
1, 2, 4,
1, 2, 4,
Five,
6 to 12,
to
14 to 20, and 22.
13, 14, 15,
Perhaps, my Lord, 23 left out.
23. What about 23?
23 is not reflected, my Lord.
What is the service report by registered post?
Registered post received back, AD received, my Lord. My Lord, usual process not received.
What about 23?
23 is minor, my Lord.
Represented by
Minor represented by their mother, Mothun Begum.
number
Mothun is 20, my Lord.
20 is already
My Lord. Is the wife of Pandit Ali.
and 24. 24,
24 same,
huh?
same.
25.
25 and 26 minor, my lord. He is represented,
Third. Three T.K. Bhuya, Credit Counsel for the petition, who by referring to the office note dated 9/8/2023 has submitted that AD cards have been received back from respondent numbers 3, 5, 13, 17, 21, 27, and 28. Whereas the report of service by user process is available. Full stop. This court has already observed in the order dated 17/11/2021 that respondent numbers 1, 2, 4, 6 to 12, 6 to 12, 14 to 20, and 22 have been are represented by Sri S. Johan. Full stop. The learned counsel clarifies that so far as respondent numbers 23 to 26 are concerned, they are minor and they are already represented by other respondents. Full stop. Service is accordingly held to be complete. Full stop. Please. Appeal has been
not admitted, my lord. Revision.
placed for admission after 2 weeks.
There is an interim order, my lord, 18/15.
Interim order passed earlier. Last occasion it was not.
My lord, it is a conditional order, my lord. If not registered steps taken, my lord, automatically it will be vacated.
It was not extended on last occasion.
It was extended prior date, my lord. It is, my lord, 18 till next day.
Interim order passed earlier. Extended till the next day.
Deeply applies, my lord.
Mr. Goswami? Yes, Madam Board of Court.
May it please your lordship. Your lordship may peruse laws in my court order dated 13/6/2023, your lordship. Service is completed upon the respondents.
13?
13/6/23.
Report Thakur.
Lordship.
MS Report Thakur and counsel for the applicant has referred to the order dated 36/2023 passed by the learned Alimony Court, as per which service upon the two respondents is held to be complete. This service is complete,
Lordship.
the matter may be listed for consideration. When
Lordship, I is for condoning the delay of 26 days, your lordship.
since service is complete, the matter is taken up for consideration. Full stop. The learned counsel for the applicant in support of her prayer for continuation of delay submits that the delay is of 26 days
26 days.
and has occasion because of certain circumstances which were beyond the control of the applicant. Full stop. attention of this court has been drawn to the averment made
In para 2, your lord.
in paragraph 3 of the application. Not 3,
Para 2, your lord.
para 2
Yeah.
of the application. Wherein it has been stated that since the regional office of Guwahati was required to be consulted for filing of the appeal against the award passed by the learned tribunal of Golaghat, some delay had occasion, and there was neither any intent, which is neither intention or deliberate. After hearing general counsel and taking into account the subtle law holding the field of consideration of an application for coordination of delay, which requires a justice-oriented and a pragmatic approach of the delay of 26 days in preferring the appeal is hereby concluded, and the court of high according to them. In view of the order passed today, that is in I 1300208, whereby the delay in preferring the appeal has been concluded, register this appeal and list it for admission after a week.
Obliged.
Any matters where interim order is today?
44, my lord.
Interim order.
Yes.
Any other? Any matter, urgent matter, you can request the court for a date. Where petitioner is, the other side is appearing in person, we fix a date in this case.
In that case, because he has other other one cases, item number 40 was also in his case.
Which date, give us the date.
I don't know.
Give a fixed date so that he can be in a position to appear.
30 or 31, doctor.
30.
I will inform him, doctor.
All right, but which item? Interim order?
46. That is interim order, that may be continued.
Okay.
Deeply obliged.